Good morning, Judge.
Morning. Is Mr. Botha on board?
Yes, indeed, my lord. He's right there and he's ready and able.
You got that much confidence in him. Let's go, Mr. Botha. We have a lot of confidence in you.
Sorry. I have enough confidence in myself, but let's carry on.
Good.
Sorry,
Good.
If I could just have 3 minutes just to, I know I ended off yesterday, but if I can just have 3 minutes, I think
Sure.
because of the graveyard shift, I didn't provide the court with the case lines references for the facts in terms of the last question posed by the court, and just to assist the court in determining the matter. The court asked me why in-person worship is so necessary as against contemplative prayer. And with regards to Antioch, the doctrinal beliefs are set out extensively in their founding affidavit. If I can give the court the case lines reference, it's 007-6-100, paragraph 26, 007-6-103, paragraph 36, 007-6-122 from paragraphs 89 to 93, and 016-1-668 paragraphs 34 to 40. And insofar as
you say 007-6, and then you say -100 n? So it's 00 devil. I see, okay. Because it's 0.6, and then the page number is 100?
And 22. So
122.
Then, my lord, with regards to the SANCF, in terms of that particular question, what we have set out in our founding papers extensively is the fact that these are pastors who they actually launched the application as against 2 pastors committing suicide and pastors with no food. And that was as against the fact that these are pastors who do not necessarily attract a financial tithe or a financial stipend. In many instances, the community arrives on a Sunday with groceries, and that's the context in which they operate. So they cannot actually have 3, 4, 5 weeks where they sit at home in contemplative prayer, because it actually essentially means that they are starving. And that goes back to what my learned friend and my learned senior said. This is a matter pertaining to dignity. And the case lines reference in that regard is 001-2, page 4, paragraph 5.1, and 007-2, page 54, paragraph 43. And that also ties in with the paragraph 11 of the Esau judgment, my lord, of the SCA, in terms of the fact that for these particular applicants, the UIF and the COVID relief in terms of social grants is simply not available to them. And that is not disputed by the minister. So for them, it's a matter of life and death.
But UIF relief would only be made available if they were employed. Employment insurance fund.
So my lord, what we set out is the fact that they have attempted to obtain UIF relief as well as the COVID assistance, and they don't qualify, given the fact that they are technically not employed. It's a vocation, it's a calling. And that's not disputed by the minister. My lord? Boitumelo, I think the judge is frozen.
Yes, my dear. I will just call judge now.
Thank you.
Not again. Is this helping? Does this help if I go offline?
Yes, indeed. Thank you, my lord. Those are my submissions. If the court...
With Martin, before you go, but you said the COVID assistance is not available to them. Now, they weren't earning anything anyway, as you just said. These are not pastors who earn money out of it, some tithe. So I'm getting a bit, I'm not sure. What is the case? Is the case that, look, we need to perform our we need to perform our religious rites in a manner that allows for communal meetings? Or is there a case that we cannot do this and we're losing an income as a result thereof?
So, my lord, it's actually a combination of both. So what the SANCF and their pastors say is that they meet on a Sunday as a body, this body that we were talking about, which continues to be mutilated through COVID regulations. And part and parcel of that worship and that gathering on a Sunday is that there will either be some sort of small financial contribution from congregants, but that is unlikely given their situations, their financial situations. It's a matter of congregants bringing food and groceries for the pastors. So what happened in the weeks preceding Pastor Josiah launching the Urgent was that two of their member pastors actually committed suicide. And then
but do we know, is that because of these restrictions?
Yes, my lord, and we set that out in our founding affidavit, because not only...
Correct. I mean, can we say definitively that the suicide was caused by the restriction?
Well, my lord, what we do attach in our founding affidavit is an article dealing with one of the pastors that actually dealt with the fact that he had felt in the preceding weeks leading up to his suicide an immense amount of pressure and depression, in the sense that pastors are not classified as essential service providers. He couldn't perform his ministry. He was being met with a situation where he was being facing arrest after hours, and there was a cumulative stress. What Pastor Josiah then goes on to say, in particular for those particular references that are provided to the court, is that he received reports that pastors were actually starving. They had no food in their homes by the time that they launched the affidavit, the application. And that is also why
this is the problem now. I'm not sure if their case, are they saying their religious activity is also their economic activity?
Yes, my lord. It's not only their economic activity, but it's part of a communal activity. So their act of worship on a Sunday not only sustains them spiritually, but that is the only means that they have. So they are unique. And once again, that is completely different from organized religious sectors who might have the financial means to sustain their ministers during hard times. And they represent, the SANCF represent an unheard plethora of pastors who, as I said, are unseen. And that is why we are representing them pro bono. They simply do not have the means. And that is why I also said that because of the nature of the sector that we are dealing with, it's imperative for the minister to consider this going forward in terms of an outright prohibition of faith-based gatherings, my lord. Is there anything further that the court would...
Yes.
Sorry, my lord, just lastly, the fact that they don't have access to Zoom and Teams, that case line's reference, 007-2, page 53, paragraph 40, for them and their pastors.
Advocate, I'm not sure whether Judge can hear you or if Judge is still online. Let me...
I'm there, I'm online.
All right, Judge, thank you.
Ms. Martin, during level 5, when the entire economy is put on hold, this problem remains there. In other words, now there's not a discrimination argument. So we went on level 5, and I understand we went on level 5 in March 2020. On 29 April to level 4. I'm not sure even level 4, all gathering bans except in level 4 also there was still a ban on religious gathering. 20 until about, I think we then came to level 3 in June 2020. When we went to level 3, so March, April, May, they were in the same situation.
I'm sorry, my lord, you keep cutting off. It's very difficult for me to hear your question. I think it might help if perhaps
I'm going to leave and come back.
Thank you.
looking at the, because you're saying 007 something. I go now to case lines. So I just want to clear this up so I get the record, get my notes correct. I go to case lines. When you say 007, 2, what do you mean? Because 007 is your amended notice of motion. And then, are you saying point 2? I can find your founding affidavit, paragraph 40. Where you talk of Zooms. That's the one you referred me to. Then you referred me to paragraph 36.
So it's, my lord, it's 007 and it's folio 6. And yeah, so that's the affidavit from Andre Pieterse of Antioch. And it's paginated page 100, paragraph 26. Can my lord find that?
All right, so then just tell me 007.
Yes.
Well, I see you don't have them chronological. They go as 007 and 6, 0072, I see. And it's paragraph 22. Let's see what that says. Paragraph 22. The one that accommodates 400 people.
No, my lord, the references are folio 007, folio 6, paginated page 100, paragraphs 26, and then paginated page 103, paragraph 36, and then paginated page 122, paragraphs 89 to 93. That is for Andre Pieterse's affidavit pertaining to the issue of doctrine for in-person worship. Then we get to his replying supplementary affidavit, which is found on case line 016 and folio 1 at paginated page 668, and it's paragraphs 34 to 40. That's for Andre Pieterse of Antioch. And then with regards to the SANCF, it's found on case line 001, folio 2, paginated page 4, paragraphs 5.1 and 6.8, and then 007, folio 2, paginated page 54, paragraph 43. And then lastly, with regards to online access, it's 007, folio 2, paginated page 53, paragraph 40.
Okay, thank you.
Then,
now, here's the question.
Yes.
When we went into level 5 and we came out of it, we went in level 5 in March 2020. We came out of it in June 2020. All activities were stopped. If your argument is correct, there will never be a time when we can ever go into a full lockdown.
Well, my lord,
it's not even a discrimination argument. It's not even an argument that, other people are allowed and we're not. It's an argument that whatever everybody else can stop, but we will never be allowed to be stopped.
Well, my lord, what it actually essentially boils down to is that is indeed correct as against the situation of, in particular, the first and second.
They can't be correct in our law.
But my lord,
then they can do that. Then basically the minister's got no powers. There is nothing we can do. We must just leave people to do as they please.
Well, there are two issues to that. The first is that obviously there's a broader argument of the fact that pastors are non-essential. And that will be developed by Adv Botha as to whether or not pastors should be seen as essential service providers. That's the first leg. But the second leg, my lord, in terms of the question, is why
essential service workers were allowed to work, in other words.
Yes.
They were the workers that are defined in terms of Section 77 of the Labor Relations Act, I think, if I'm correct. And your clients want her to declare you essential service when Section 77 says that is done by the Essential Services Committee. She doesn't have powers to determine who can or cannot be declared essential services.
Well, my lord,
No, because I was chairman of the Essential Service Committee for many years.
Yes. My lord, there are two aspects to the argument. The first is the essential service aspect, which is an argument that Advocate Botha will develop. In terms of the original question, which is, well, how did they sustain themselves?
No, that's not only the question, whether they could or couldn't. No, the question is, if you're right, there can never be a prohibition against them. Regardless of the circumstances, no matter how much there's a spread of this virus, they must be allowed to work.
Yes,
that's what your argument is leading to.
Yes.
Surely that can't be right.
Well, my lord, I would submit that in terms of the nature, in terms of which they operate, that would, of course, be a necessity. The reality is that they are not essential service providers, and they are sitting with a situation where, as the court says, what is the difference between the beginning of lockdown and the December situation when we originally launched the urgent application? And that, my lord, is found predominantly in actually Antioch's affidavit. And that is addressed at case line 007 or folio 006, paginated page 101, paragraphs 28 to 34. And it is also addressed by SANCF at 007-0002, paginated page 47. And what both deponents say essentially is that when the country was originally locked down, there was an attempt to comply diligently. And the fact of the matter is that the churches now have faced 3 prohibitions. The first was the march, an outright ban for the entire country, 2020. The second one was December 2020, when...
So lockdown level 4 also there was a prohibition. So it was March and then it was in April 2020.
Yes.
So there's 2 of them there.
And
in
the December prohibition, 2020, which led to this application, and then again in June, July this year.
Right, prohibition. So between June 2020 and December 2020, there was no prohibition.
Yes, my lord.
No prohibition. Right.
So what the deponents say factually, my lord, is that, and what's very important is that in October 2020, which we analyze, is that norms and standards are released by government for churches to say, this is how you operate safely. Exactly the same attitude to business. And what the deponents say is that they have diligently complied, and in particularly the SANCF as against extreme poverty. And they set that out from paragraphs 21 to 25 of their founding affidavit, where they state that the difficulty that they face is that the ongoing prohibitions, one after the other, is becoming utterly untenable.
Well,
and that,
let's take a situation, and I'm not saying the December one was there. I'm just trying to understand your argument. Let's take a situation where there is a super spread around the country. There's just been, we're getting huge numbers of people being infected. On your argument, we can never, ever prohibit them because you want them declared essential services, which, by the way, the minister cannot do. That's going to be done by somebody else. She doesn't have that power. She'll be acting ultra vires. So, assuming she could do that, according to your argument, they will, no matter how bad the situation is, they will always be allowed to operate.
well, my lord, Essentially, yes, that is what we are fighting. That is the core nexus of this application. Is it an outright prohibition of meeting on a faith basis? Is that actually sustainable in terms of Section 15 of the Constitution read against Section 36?
Okay, well then that
the argument ties in with the sensitivities of the first two applicants, that this is a situation where they are actually living hand to mouth. And they are living hand to mouth as against the fact that they are excluded from any kind of government assistance in terms of the Disaster Management Act, and hence they are particularly vulnerable. And this is why I say, my lord, that this is a sector that the minister needs to consult with. So the broader...
What is this sector that's different from the sector represented by all the other religious groupings? And you must go and find each of the groupings that you must consult with. Must you know all the details of every religious practice, of every little grouping?
My lord, I addressed the court on that yesterday. That in this regard, what makes it quite distinct is, first of all, the SANCF went to the time and the trouble to be recognized by the Center of Religious Rights to be a proper governing body overseeing a certain sector of faith-based organizations. But the other aspect which I brought to the court's attention is that prior to the launching of this application, all applicants specifically requested consultation with the minister, which requests have been ignored. And that the case lines reference for that is case lines 15, folio
015.
And it is annexures, paginated page 218 to 219.
Okay.
And the messages are found at case lines 20, paginated pages 228 to 229.
Yes.
My lord, just to show the court the rationality of a prohibition as against, for example, the debate that actually was presented to the court at the beginning of yesterday morning between two senior counsel as to particularly regulation, if I can just find it. It was the June regulation, which reads as follows.
The June 2021.
Yes, so that regulation...
The June 2021 regulation is not before court.
Well, my lord, it's law.
Okay.
It's law.
I have to take it into account. It's law.
It's law. It's not an issue of fact.
Right.
Yes. But, for example, it says the following. Gatherings at community engagements hosted by members of parliament, members of provincial legislatures, councillors, leaders of political parties, religious leaders, and traditional leaders to deal with emergency matters that impact on the management, treatment, and prevention of the COVID-19 pandemic are permitted subject to a limitation of 50 persons. And then it proceeds. Now, my learned friend for the minister made the submission that this is a regulation that doesn't pertain to faith-based gatherings. It pertains to the looting. And it was pursuant to the looting. Now, once again, my lord, when does it become a faith-based gathering and when does it become a gathering specific to the looting? Because the regulation itself speaks to a gathering of community engagements and religious leaders. So and it goes back to the debate that you had with myself and Ms. Engelbrecht about the artificial nature of these regulations insofar as saying you can meet to discuss the looting and on an emergency basis, but you can't have a faith-based gathering. Now, what happens if you meet as a group of a church to discuss the looting, and then all of a sudden there's prayer and there's worship? There's no distinction between a meeting on a Sunday to worship and gathering in terms of a June-July regulation to deal with the disaster, with looting. So the distinctions that government are making are entirely artificial as against the actual practical reality. Just to show the artificial nature.
I'm not being convinced that the minister, is expected to be absolutely scientifically accurate and perfect in every single aspect for her regulations to pass muster. Given the circumstances she's operating under, there will be some irrationality here, there, and everywhere else. There's irrationality in so much. There's irrationality and or differences of opinion in so much of everyday life and practice. To expect her to get it right on every single aspect is demanding a bit too much. It's taking rationality. It's being uber-rational. It's taking it to its umpteenth level. It can't be the right. Our law can't expect or put or impose such a burden on her. It can never do that. Not the law itself can never achieve that kind of certainty and absolute avoidance of contradiction and contradiction. I mean, the law itself is marred by contradictions.
Well, my Lord, let's go back to the start of the Constitution, because that's basically why we are here.
Is right. Yes,
we go back to the starting blocks of the Constitution. And for example, the preamble, and we've raised this in our papers as well as our heads of argument. The preamble says, "We, the people of South Africa, recognize the injustices of our past, honor those who suffered for justice and freedom in our land, respect those who have worked to build and develop our country, and believe that South Africa belongs to all who live in it, united in our diversity. We therefore, through our freely elected representatives, adopt this Constitution as the supreme law of the Republic, so as to heal the divisions of the past and establish a society based on democratic values, social justice, and fundamental human rights." And then it proceeds, "May God protect our people, Nkosi Sikelele, Morena Baloka, Sachaba Saheso." Now that portion, as we've analyzed, was crafted by a Black Methodist minister in the 1800s. It was the symbolic archway between the horrors of apartheid and the hope of a future. Our Constitution is actually founded on a hand-in-glove approach with faith-based communities. It is not within the ambit and the purview from a constitutional perspective and a Disaster Management Act perspective, as I submitted yesterday, to simply exclude faith-based organizations at a whim. And the irrationality, for example, of June, July 2021, is that on the one hand, they were prohibited from meeting again. And on the other hand, when there was looting, all of a sudden, there was a regulation which permits...
But then you're asking for accurate, non-contradictory practices. And I'm saying, where in life can you get that? We're back to the point. First point is, but isn't there, I mean, a lot of other faith-based organizations were prohibited. And they all found it okay, and all fall within the Christian faith. And same with the Muslim faith, and same with the Jewish faith. Then comes some other little grouping, some other groupings who also fall within that faith. And they say, but we've not been consulted, and our practices are slightly different. So now, how do we go? Where do we draw the line? And what are we expecting of the minister?
Well,
and that's what I'm saying. Are we not imposing too heavy a burden?
My Lord, at the end of the day, in terms of this application,
any human being to operate in those circumstances.
In terms of this application, to answer that question, my Lord, and then I think I'll hand over to Advocate Botha to develop the argument as against precedent, is in this particular matter, as I identified yesterday, we have absolutely no scientific evidence whatsoever linking an outbreak of COVID with the faith-based community. And as I indicated yesterday, if one has regard to the Botha judgment, which found that the regulations in that regard as against the tobacco industry were irrational, a lot of evidence was produced by the minister specific to the tobacco industry. That has not been produced in this application as against the faith-based community. There's absolutely no evidence presented by the minister, save for bald assertions. There's no factual data to say this is informing the different levels. This is that decision.
Absolutely. Before she can act.
I'm sorry, my lord, I'm really battling to hear you again. You are breaking up.
Hello.
Judge, you are breaking. We can't hear you, Judge.
Video off.
Sorry, Judge, we can't hear you.
Okay, I'm going to. Can anybody hear me? Please put your hand up.
We can hear you now.
Can anybody hear me?
We can hear you now, my lord.
Ms. Martin, can you hear me?
I can, my lord. My lord, I think that for the purposes of not taking up too much of my other...
You leave it to Mr. Botha.
I'll give it to Mr. Botha. I have addressed the court with regards to the factual aspects as against the three applicants. And if there are any further questions, then I'm more than happy and willing to address the court in my reply. I just don't want to over encroach on my time, and I'm very indebted to my opponent and to my colleagues for affording me the opportunity to just provide the court with those case lines references, and to the court for the indulgence. Thank you very much.
Thank you, Ms. Martin. Mr. Botha?
As the court pleases.
Thank you.
My lord.
You've got a few points to speak about, but being the most senior representative of the applicants, I want to deal with this question, if you can, of polycentricity. Because there seems to me a theme that's running through the applicants' cases, which is one, there's discrimination and there's lack of rationality. And on first lack of rationality, we can pick out examples of when we can meet here or when we can't meet, and when we can't meet there, yet we seem to have an overlap in the activities that we are engaging in when we meet. Now, that's their second case. So their first case seems to be that there is, what did I say? That there's arbitrary and irrationally, that there's arbitrariness and irrationality on the part of government in passing this regulation. And linked to that is this issue of the part of government not being able to justify each and every single possible activity that could take place and that may fall foul of the regulations. Now, that requires some sort of absolute proof on the part of government that it's taken into account every piece of evidence and that it has actually gone out there and collected and collated all that evidence. And I'm saying, given the circumstances under which they work and given the nature of the issues they're dealing with, is this not really a policy issue that they have to make a policy on, especially when there's so many conflicting interests they have to deal with? A court is not capable, and the
Sorry, my lord, you're cutting off.
Of the hello?
I can hear you now.
Okay, so let me just cut it short then. Can you just deal with this issue if you prepared on this issue of?
I think I can, and
And in the course of your...
you want me to deal with it up front, or can I develop it as I go along? Sorry, my lord?
Develop it as you go along.
Okay, but I can just refer your lordship to the Necro judgment at paragraphs 35 to 37, where this very issue is addressed pertinently by the Constitutional Court. The Constitutional Court says that in a justification analysis, facts and policy are often intertwined. There may, for instance, be cases where the concerns to which the legislation is addressed are subjective and not capable of proof as objective facts. A legislative choice is not always subject to courtroom fact-finding and may be based on reasonable inferences unsupported by empirical data. This is what your lordship is putting, as I understand it. But the court then goes on to say this: when policy is an issue, it may not be possible to prove that the policy directed to a particular concern will be effective. It does not necessarily follow from this, however, that the policy is not reasonable and justifiable if the concerns are of sufficient importance, the risks associated with them sufficiently high, and I want to underline that for present purposes, and there is sufficient connection between means and ends that may be enough to justify action taken to address them. Where justification depends on factual material, the party relying on justification must establish the facts on which the justification depends. Justification may, however, depend not on disputed facts, but on policies directed to legitimate government concerns. If that be the case, the party relying on justification should place sufficient information before the court as to the policy that is being furthered, the reasons for that policy, and why it is considered reasonable in pursuit of that policy to limit a constitutional right. That is important, for if this is not done, the court may be unable to discern what the policy is. And the party making the constitutional challenge does not have the opportunity of rebutting the contention through countervailing factual material or expert opinion. A failure to place such information before the court or to spell out the reasons for the limitation may be fatal to the justification claim. There may, however, be cases where, despite the absence of such information on the record, a court is nonetheless able to uphold a claim of justification based on common sense and judicial knowledge. Ultimately, what is involved in a limitations analysis is the balancing of means and ends. This entails an analysis of all relevant considerations to determine the proportionality between the extent of the limitation of the right, considering the nature and importance of the infringed right on the one hand, and the purpose, importance, and effect of the infringing provision, taking into account the availability of less restrictive means available to achieve that purpose. That is really the test. There's two further cases which deals with this. The one is S versus Lawrence. It's been quoted before, where, at least in the judgment of O'Regan, the court adopted the approach that government was obliged to place concrete evidence before the court in order to justify a limitation. And also in the Makwanyani case, my lord, where the court said, as it related to policy decisions, the following, that and it was dealt with in the context of rationality.
Paragraph on Makwanyani, because it was a lengthy judgment.
Paragraph, I think it's paragraph 156. I got the note, but I'll double check it. Where the court says, obviously, an arbitrary decision cannot be rational, and that's also accepted in the pharmaceuticals case. And the court said arbitrariness must also inevitably by its very nature lead to the unequal treatment of persons. Arbitrary action or decision making is incapable of providing a rational explanation as to why similarly placed persons are treated in a substantially different manner. Without such a rational justifying mechanism, unequal treatment must follow. And that really leads me into, my lord, to my main address, because I want to focus on the two core rights in issue, because really, ultimately, this case is about justification. There can be little debate that the regulations infringe the right to religion. And I think also, I submit also that there can be little debate that the regulations infringe the right to equality, which has an added protection for religious communities, because religion is a listed ground. And none of these rights that we rely upon, my lord, have any pecuniary interest attached to them. And by exercising those rights, one does not derive any income. these rights are protected
Well,
because
except what Ms. Martin is arguing.
Sorry, my lord?
Except what Ms. Martin is arguing.
Well, there may be overlap where certain religious communities earn income, but our case is based particularly on the non-pecuniary interest, which we emphasizing, and whether that can be trumped simply or diminished simply because one cannot make an income from it. And that is the core of our submission, because if one looks at the Pillay case, and I do rely heavily on it for some of the statements that I will make, the court is very clear as to the basis as to why religion and cultural practices are protected. And they are protected because they are central to human identity and hence to human dignity, which in turn is central to equality. Many of the rights in the Constitution don't have any pecuniary value. They are protected and even elevated because of non-pecuniary interests and values attached to them. In fact, the three core rights in the Constitution, which is the right to equality, the right to dignity, and the right to freedom, often do not have any pecuniary interest attached. The reason that they are elevated above any other rights, even the right to earn one's income, is because of the fact that these core rights give human beings their human identity and allow them to express that identity and confer upon them the dignity that they deserve as human beings. So to tell a person, my lord, who's standing across the Gold Reef Casino, and your lordship knows what I'm talking about, opposite the Gold Reef Casino, just before you get there, my lord, you'll see a big mosque. We call it the Ferrero Rocher Mosque because it has a gold dome and a brown dome. And directly opposite the casino, you'll find another masjid with a white dome. It's clearly visible to anybody driving up or down the N1, coming or going from town. And to tell a religious person, listen, who can see right across the road, the cars parked at the casino, that you can't enter your mosque to pray, but another person who wants to gamble can go into the casino and gamble just because that person is helping somebody to earn an income, is elevating pecuniary interest over dignity. And that can never ever be a rational explanation for differentiating between religious interest and pecuniary interest. Because the core right that is protected in the Constitution is the right to dignity. And my lord, I want to tell you, I just want to indulge you a little bit and take advantage. I didn't realize I was the most senior person here, but you and I and Mr. Makhagabi go a long way back, my lord. And you'll remember when we joined the bar in 1996, my lord, Mr. Makhagabi was already there. But things were not great at those times. Racism was rife in the legal profession, and religious intolerance was still rife in the legal profession. And you and Mr. Makhagabi were at the forefront of fighting that, and I think you probably still are doing that in your own spaces. But I want to tell you a story, my lord, and if you just indulge me, it will strike home in a minute. I was arguing a case in the High Court, and at that time I did a lot of motion court, opposed motion, commercial practices. It was a provisional sentence case about architect certificates, and I was acting for the defendant, and I didn't have a great case, I must confess. But it was on a Friday when we were arguing this case, and it was around 12:20, and I was before a judge from the previous era. I'm not going to mention that judge's name. And as was my custom before the matter started, I had arranged with my opponent to indulge me and to accommodate me to stand the matter down at 12:30 so I could attend the Jummah prayer, which your lordship knows is a compulsory congregational prayer for Muslims. And my opponent had absolutely no difficulty with it. And I, as was my usual custom, I told him, look, we can, to make up the lost time, we can start at 1:30, or if the court wants at 2, and we can take half an hour extra. He had no difficulty with it. When 12:20 came, I stood up and I asked the learned judge for an indulgence to go to the masjid. And he didn't, like the regulations tell me, no, you're banned from going to the masjid. He was somewhat more clever. He said to me, well, if I'm going to indulge you to go to the masjid, this case has to be postponed because I'm not available at 2 o'clock. And perhaps this case will only see the light of day next year or whenever the role allows it. He then forced my opponent, who was acting for the plaintiff, to stand up to object to my request for a postponement. And the result was that I was denied that right on that day to go for Juma prayer. I managed to make the prayer in congregation during lunchtime. But that single experience has never ever left me. It will never leave me. It's a story I will tell to my children, to my grandchildren, and to everyone in the profession, because this is what we came from. This is the past that we came from. And the fact that I was allowed by every other single judge to attend Juma prayers every other day for the 20 or 25 years after that has not diminished 1 ounce of the anger and rage I still feel when I think about that one incident. Why, my Lord? Because I was robbed of my dignity on that day. So to tell a religious person that you can't go to mosque or you can't go to church or you can't go to wherever, temple or synagogue, when this is an expression of the identity, to tell them that on one occasion is enough for a court to, when there's no justification, to grant redress. You don't tell somebody who's detained for 5 minutes that you got to tolerate this detention because the people in Guantanamo Bay are detained for 25 years. You don't tell somebody whose privacy is invaded for 5 minutes that they got to tolerate the invasion of their privacy for 5 minutes because others have tolerated more greater invasions. You don't. Nobody reasons like that. You don't tell somebody who's a victim of a racist statement, which may have been uttered in a matter of seconds, that they must forget that racist statement because the person never ever after that expressed themselves in that way. That is just illogical and bizarre to be able to diminish rights in that way. So the idea that these infringements were temporary has no logical basis. Every single time a person was prevented from the masjid is going to leave a lasting scar on them for the rest of their lives. The police came to masjids, treated people like criminals, threatened to arrest them, closed down masjids. My Lord, do you think that the pain and the hurt felt by all of those worshippers who were prevented from praying on all of those days is simply going to go away because now today they can go to the mosque? That is not the way the Constitution works, my Lord. These infringements are core infringements. They are infringements to core rights. And the Constitutional Court has already said in the Christian education case that the right to practice one's religion includes the right to do so individually or in community with others, in public or in private. That point is settled. The Pillay case made it also clear that regardless of whether or not the right sought to be asserted forms part of the compulsory aspects of the religion or whether it is merely voluntary, both deserve protection. The first deserves protection because it gives people a Hobson's choice. And we say, my clients say, that the establishment of the 5 congregational prayers is compulsory because it is a compulsory duty placed on the community as a whole. But regardless of that, in Pillay, the court found that Ms. Pillay's right to wear the nose ring did not derive from the compulsory aspects of a religion, but derived from the voluntary practices of that religion. And the court said that indeed, it seems to me that it may be even more vital to protect non-obligatory cultural practices. Why? Because that's where people exercise their choice truly, because there's no element of conversion. So whether or not somebody is deprived from going to a masjid or mosque or church because it's a compulsory aspect of their religion, or whether or not they are deprived of doing so because they want to practice a voluntary aspect of the religion, the infringement is no less serious. And the Constitutional Court has made that absolutely clear. So there's no challenge on the papers, or no serious challenge that the right to religion has been infringed. So now, my lord, we go back to the justification inquiry in respect of the right to religion. I've already read out the Necro case. In fact, the state relies on the Necro case in paragraph 127 of its heads of argument. But what they don't do there, my lord, is they don't give the full quotation. They only quote selective portions of their judgment. I've read out to your lordship what the Constitutional Court has said. In a case where like this, where the government is imposing bans in order to alleviate or ameliorate the spread of the virus, that does involve elements of policy. I cannot dispute that, but it also involves elements of fact, because it does require one to be able to demonstrate the relationship between the ban on the one hand and the relationship between the means and the ends. The ban, does it actually derive or actually achieve the purpose? And this is where the justification analysis becomes very important, particularly with reference to the availability of less restrictive means. Because if one looks at the regulations itself, I just want to read out to you, I just want to show to your lordship or read out to your lordship what the regulations said, for example, with respect to casinos. And this is what it said. Just bear with me, my lord. I just want to find it. Yeah, this is at sub 7. Gatherings at casinos are limited to 50 persons or less for indoor venues and 100 persons or less for outdoor venues. Now, this is important, what I'm going to say now. And if the venue is too small to hold the prescribed number of persons observing a distance of at least 1.5 meters from each other, then not more than 50% of the capacity of the venue may be used. So even if you can't social distance 1.5 meters, you can still carry on running your casino with this accommodation. Now, my lord, why on earth could this simple accommodation that was given to casinos, to cinemas, to theaters, to museums, and all of the other gatherings which are permitted, not be courteously extended to religious communities? We're not asking for mass gatherings. We're asking for simply the same accommodations to be provided to us as others. Now, that's where, my lord, the discrimination itself manifests very clearly. Because we have premises, we have buildings, and casinos have buildings. And they can use their buildings to a limited capacity. We've got no problem with that limitation. We don't want them to stop it. Our argument is not that they should be stopped. We understand that people need to make a living, but they can use their premises, but we can't use our premises for the purpose for which they are built. And the only reason the legislation, the regulations differentiate on that is because our activity is faith-based activity.
No, that's not the only reason, Mr. Botha.
It's the main one, my lord.
Yes, the minister is struggling, as I read her papers, with this dilemma: protecting livelihoods and protecting lives, and the two come into conflict at some point in time. Now, even in her level 5 lockdown, she had to compromise on livelihoods, on lives with regard to essential service workers, particularly health workers. The result was, and we're all aware of it, a lot of health workers had suffered the fate. So and that's not something she had to do. She did not stop them because they were earning livelihoods there. She was stopping them because they were necessary. I don't know if we can do that essential service argument for some of the people here. But other than those, she didn't allow anybody. As a result thereof, a lot of livelihoods suffered. And she puts that in her papers of the growth in unemployment and the desperation people found themselves in. And as courts, we see it all the time, people who are not able to now meet their daily expenses, such as rentals, etc., and bond payments. So now she's struggling with that in this a year later. And she says, I'm going to allow the livelihoods, but to a limited extent, and still protect lives. As far as the non-pecuniary, as you call it, activities are concerned, I'm going to dare protect lives altogether. So she's taken a decision which compromises lives in the pecuniary situation, as you call it, or I call it the economic one. She's recognized that she's compromising lives there, but she's forced to do so because she's trying to protect livelihoods. Now, that's a perfectly rational way of looking at it, and it's a policy decision she takes.
My Lord, I don't believe that the minister's case is that I made these accommodations recognizing that there's a threat to life. Because if that was the case, we would go back to the hard lockdown. Because that was the case in the hard lockdown.
But
in this case, sorry, Manu.
I thought that is her case. She said
No.
There's a spread, lives are lost. There's a huge demand on the health services, and of course, all this then places greater risk on the health workers.
Yes, but my Lord,
you take all of that, and in the spur of the moment, make this decision. At the same time, I realized my hard lockdown, necessary as it may have been, under the circumstances of the information given, under the circumstances then, largely based on the information we had. She says, I recognize that, so I'm not going to allow that kind of hard lockdown again, because I want to protect some livelihoods.
Yes, but my Lord, I've already indicated. I'll deal with the rationality. I've already indicated that there's no constitutional basis to undermine religious rights simply because one doesn't derive an income from them.
It's not so much it's protecting your livelihood. I know it's bestowing on income, and she's saying to you, but pray in different forms, find another way until we resolve this problem. Now you come back and you say to me, but even if it's 5 minutes, she's not arbitrarily detained someone for 5 minutes. It sounds like a good example, but it's not entirely appropriate. She's saying, I'm holding you because there's a threat out there. I'm keeping you here for 5 minutes. I need to clear that threat. Those people are burning houses.
But my Lord, where is the empirical evidence that gathering for 5 minutes will result in a risk? There's nothing. We've produced an expert report that shows that the very opposite.
There's been so much evidence of spread.
But my Lord, there's no evidence.
There are people who have died as a result thereof. And she gives it one example in her papers. She mentions only one. When she talks about the initial spread by those people who came from overseas. She mentions that in her answering affidavit. They came and they had a religious gathering somewhere, and that resulted in a spread. And I think that was the Fons et Origio of the spread in our country.
Yeah, but we're not asking for mass gatherings. But my Lord, let's look at this. Cinemas, theaters, casinos, museums, galleries, archives, gyms, and fitness centers, restaurants, venue hosting auctions, venue hosting professional sports. Now, I mean, at the gym, is the risk at the gym, my Lord, where people are exercising and taking their mask off, greater than the risk at a masjid or a mosque? There's no empirical evidence that...
No, but there is this point. She knows that. She says, she's aware that that's going to increase the spread. She then mitigates that and says, the only reason I'm allowing this is because I'm protecting livelihoods.
But my Lord...
You want to stop that person who's employed from being denied the opportunity to earn that income.
Yes, but my lord,
That's the only reason I'm doing. If I could help it, I
But-
wouldn't do it. I'd have the full lockdown.
with the greatest of respect, my lord, you're undermining the importance of religion to an individual's human worth. People's identity are inextricably linked to their religion. In fact, many people live their entire lives based on their religion. They govern their lives from the time they wake up to the time they sleep based on their religion. Now, with the greatest of respect, my lord, there's no evidence that suggests, I mean, from that first example, the minister has from the Muhammad case until now, where is there any evidence that suggests that there was one spread of the virus from a small religious gathering in a masjid, where precautions are taken?
There's anecdotal evidence of people getting it in the mosques, and some of them have not made it. There is that evidence.
I don't believe there's anything like that, man. I don't believe there's any evidence before you, anecdotal evidence that in a small mosque gathering where people come in, take their shoes off, have to perform ablution, and most of the mosques implemented precautions, sanitization, that there was any. In fact, I don't believe there's anything on the paper. Certainly in our answering affidavit, I haven't read anything put up by the minister that suggests that the virus was spread from a small gathering. In fact, when I read the heads of argument,
Mr. Botha, I don't want us to misunderstand each other. I'm not saying that there is scientific proof that it grew in this mosque, that mosque, or another mosque.
Yeah.
She may not even have that evidence. She may not. Because to acquire accurate data in these circumstances is extremely difficult. Because people move from one area to another. They come from a mosque and they move elsewhere. Whether they got it in the mosque or elsewhere, we don't know. There's just so much of uncertainty. But we do know that once they do have it and they do go into a mosque, even if they didn't get it at the mosque.
my lord, that's not their pleaded case. What I can refer you to
is common sense, Mr. Botha. So,
my lord, you can't say that.
We are in an outbreak in this period between December and January. She says we've got a fourth outbreak.
So my lord, why
stop it? I just want to do this to the moment of stopping it now. And then a month later, she says, I've now found we managed to control what we want to. It's like telling you, I can't let you go down that road. I'm going to have to hold you here. That's a detention. Until such time as I clear the danger. There are people burning tires. There are people doing, I'm going to hold you here for your 5. I'm using that as your own example. I'm going to hold you here even for half an hour. I won't let you get into your house.
But I can go to the casino. I can go to the shop. I can go walk in a museum and the park.
We're back to the point that for economic, to save that other person's job, otherwise he's going to be fired or she's going to be fired, and she needs to feed her family, and he needs to, and so I have to work out, how do I do this balance? And I'm saying, are we not expecting too much of her?
No, my lord, we are expecting reasonable accommodation.
The court not taking over her function.
No, my lord.
Not saying no.
We are expecting reasonable accommodation, my lord. I mean, if your lordship, and I want to get to the equality part of it, my lord, because I haven't addressed your lordship on that yet. Because we know from the Haxon and Lane test, my lord.
Yes.
And unfortunately, people don't quote the full Haxon and Lane test very often. Many of the times in textbooks, they don't quote the Haxon and Lane test properly. But we know there's different stages to the test. And the first stage is their differentiation between people. And then if so, does the differentiation bear a rational connection to a legitimate government purpose, which is where your lordship is. But then the second part of that portion of the test, people don't quote it. It says, If it does not, then there is a violation of Section 8.1, even if it does bear a rational connection. It might nevertheless amount to discrimination. So what Hodgson says is that in certain cases where there's a breach of the right to equality, even if there is a rational connection, it might nevertheless amount to discrimination. Now, one case where the court bypassed the rationality analysis was the National Coalition case, because what happened there is very similar to here. The conduct was proscribed and attached to it was a criminal offense. So in those circumstances, the court said this, and this is at paragraph 18.
The National Coalition.
National Coalition, my lord, and Minister of Justice. This does not mean, this is paragraph 18. This does not mean, however, that in all cases, the rational connection inquiry of stage A must inevitably precede stage B. The court holds, the stage A rational connection inquiry would be clearly unnecessary in a case in which a court holds that the discrimination is unfair and unjustifiable. I proceed with the inquiry as to whether the discrimination on the grounds of sexual orientation constitutes unfair discrimination. So what the court there said, as I understand the case, my lord, this is really not my field of expertise, as you know, but as I understand the commentary from Cheskelson et al. On analysis of this case and why the rationality test, a part of the inquiry was bypassed because allowance was made for it in Asken and Lane, was for two reasons. One, the discrimination was on a listed ground, and two, the conduct was proscribed and attached to it, there was a criminal offense, which is what has happened in this case. Going to a mosque, even if there's 3 people or 2 people, would have attached a criminal, a potential criminal liability. So in this case, my lord, your lordship has to find with respect that there is discrimination based on the fact that the use of the premises is limited or is banned based on what is done there. And in this case, where the premises is used for faith-based practices, the premises cannot be used. If the premises is used for other recreational practices, it can be used. So there is clearly direct discrimination on a listed ground, which is religion. Now, when there is direct discrimination on a listed ground, which is religion, that discrimination is presumed to be unfair because there is a listed ground. And the state has to address or adduce evidence not only that it's justifiable, but that it's fair. So there's an added layer of protection in the equality clause, which requires the state to prove fairness and justification. And that is important, my lord, because if we go back to the Pillay case, the court says this in the Pillay case. When it deals with fairness and why it was unfair for the state to prohibit Ms. Pillay from wearing her nose ring, the court says ultimately that they could have made reasonable accommodation for her. So and it says at paragraph 72, the concept of reasonable accommodation is not new to our law. This court has repeatedly expressed the need for a reasonable accommodation when considering matters of religion. The court has recognized the need for judicial deference in reviewing administrative decisions where the decision maker is by virtue of his or her expertise especially well qualified to decide. It is true that the court must give due weight to the opinions of experts, including school authorities, who are particularly knowledgeable in their area depending on the cogency of their opinions. The question before this court, however, is whether the fundamental right to equality has been violated, which in turn requires the court to determine what obligations the school bears to accommodate diversity reasonably. Those are questions that courts are best qualified and constitutionally mandated to answer. The court cannot abdicate its duty by deferring. Sorry, my lord?
Which paragraph are you reading?
72.
72.
The court cannot abdicate its duty by deferring to the school's view on the requirements of fairness. That approach is obviously incorrect for the further reason that it is for the school to show that the discrimination was fair. A court cannot defer to the view of a party concerning a contention that that same party is bound to prove. Now, my lord, if one was simply to apply this dicta here, it's not difficult, my lord. the minister is trampling upon core rights. Everybody accepts that. The concept of reasonable accommodation is not new to our law. It's been there, it's been in foreign jurisprudence for as long as equality law exists. And that's what the minister must do. The minister must ask, can I make reasonable accommodation for these religious practices? And there's no evidence to suggest she could not make really a reasonable accommodation or limit those gatherings in the same way that she accommodated the other areas, the recreational areas. So this is not a case, this cannot be a case for deference.
Areas as she allowed that are non-pecuniary, non-economic.
My lord, a museum, I mean, there may be, I don't know if it's a public museum, there may be a few.
It's an economic activity.
But I mean, an imam or a priest, if it's that limited, will also earn their income from there. A madrasa, we put it in the papers. People run madrasas from masjids. You have teachers who are paid. You can't completely divorce.
Schools, she's not stopping that sort of gathering. That's a different, I mean, they don't fall foul of this prohibition.
No, but my lord, the police came and shut the masjid in our case.
Yes, that's where they were praying.
No, they shut the masjid. They clocked the doors. You couldn't enter it. There's enough evidence of that in our papers. You had to close it. There was this big debate about whether you had to close masjids with the police. They shut it. So what happens to all of those? But my lord, one cannot completely. I mean, we're going back to the same thing, and I think I made my submission.
Can we impute conduct of the police who may have incorrectly or may not have incorrectly, I don't know, applied the regulation onto the minister?
Well, if the regulation allowed for that, yes.
But didn't allow for it. I'm saying if they may have incorrectly applied.
Yeah, I accept that.
I accept that. Regulation.
That I accept. That I accept. I can't not.
The police's misbehavior.
No, I accept that.
The delictual action you may have against the Minister of Police.
Yeah. I accept that, but what I'm saying, my lord, is that there are pecuniary interests even in places of religious worship. So, for example, my lord, when you go to a mosque, I mean, you'll see beggars standing outside every salah, and people give them money. You'll see collections for the mosque for various reasons. There's a tin there outside the mosque. You put your charity so that the mosque can operate. Because
Mr. Botha, was not the Muslim community's groupings consulted on all of this?
My lord, I dealt with this in the Mohammed case, my lord. They consulted some religious leaders. I don't know in this round if they consulted. In the first round they did. There's no record to show that they consulted anyone from the religious community. But what I can tell your lordship, that in the Mohammed case, there was those who were consulted came in and intervened on the side of government. You don't see them here precisely because they can't understand and they can't explain to their followers why you can go to a casino and you can't go to a masjid. And that's why you don't see them.
I've just explained it to you, and I can tell that to your followers. You can tell that to followers.
But my lord,
as much as it's unwanted by the minister, it's much as she just would love to not want to have it, she is trapped.
She's not trapped, my lord. She must make reasonable accommodation.
To protect someone's livelihood. Someone's duty to put food on their table. And she has, under those circumstances, taken a very difficult decision. I may take a different decision, Mr. Botha, but that's not the test.
My lord, I've addressed your lordship on whether this is a deference question or not. And I will urge your lordship to have regard to NICRO, and I'll urge your lordship to have regard to paragraph 72 of Pele's case, which clearly says this is not a question of deference. So if objectively reasonable accommodation could have been made, then that is the finding that your lordship should come to. And there's absolutely no empirical evidence that reasonable accommodation could not have been made to protect lives. No empirical evidence whatsoever. And we've put up an affidavit of a virologist who says that the type of accommodations made in casinos, in fact, he says the mosque is a less riskier place for the virus to be transmitted than a gym or a casino. So that the chances of contracting COVID in a masjid environment, which is a clean environment where people make ablution and they don't socialize, all of that is in the papers. The chances of getting COVID there when there's restricted numbers is really, really low. So with respect, my lord, we have aptly demonstrated that if your lordship finds that there is a breach of equality on a listed ground, then the state has the clear onus of showing to the court why its actions are fair. It has not done so. It has not even addressed this question of reasonable accommodation. We're not saying, my lord, close down the casinos. We're not saying to you prevent those people who want to earn a living from earning their living. We're not saying that to you. We're saying let them do that, but allow some reasonable accommodation for people to worship. This is an integral part of their lives. My lord, I've expressed to you one incident that happened to me 25 years ago, where I was prevented from prayer, and I've never gotten over it. This causes true pain to people, and they can't understand when they see queues outside a shop or whatever, people milling around, walking around the public, all of it's not prescribed, walking around parks,
But that's not
sitting in parks.
fault. That's not the regulations' fault.
No, but this is allowed in the regulation. All of these other activities are not prescribed.
No,
So
but
why prescribe a place of sanctity where people have, where people can pray, they gain mental health? It's a deeply painful thing, and if your lordship says ultimately, well,
I mean, I don't
you can't make
I
reasonable
can't remember
accommodation.
this evidence here, but there was evidence, I can't remember if it's on these papers, of there being super spreads after some very serious, in particularly in your community, after the
My lord,
events, and it was massive
but we're
loss
not
of life.
asking for.
There was huge loss of life.
But we're not asking for
And
mass
there were
gatherings.
huge demands
But my
in
lord,
the health services. And I mean, it was all after certain incidents, certain celebratory events that took place.
I don't know if it was in
And
the
so we
masjid
know
environment, my lord. I don't see any
There
evidence it was in
a
the masjid.
massive outbreak in your community, Mr. Botha.
My lord, from the masjid, I don't know if that.
But
if
there
it
was a huge outbreak.
I don't know on the papers
We
where
know
that is.
amongst those, I don't know where it is on the papers, but we know.
There was a thing in
very high
India about the
security rate.
Ijtima gathering, spreading the virus, and that
But in your own community, when you look
19,000
now,
people.
you tell me to take judicial notice.
Yeah.
And in your own communities that you're living in, there has been high fatality rates.
My lord, it couldn't get closer to home, as you know.
I know that in my case, too.
With the greatest of respect, my lord, people got coronavirus in their houses. They never go anywhere. They sat in their houses. My father is an instance like that. He didn't go anywhere. He sat in his house. He never went to the mosque. Not one single day did he go to the mosque. And he got coronavirus. We believe as people, but we believe as people of faith that life and death comes from God, and we manage those things. We don't blame the virus for it. Our faith allows us to heal and allows us to deal with these issues.
But that's not the issue. The issue is, how does she stop the spread from someone taking, where it got it in the mosques or whatever?
My lord, she needs to make reasonable accommodation. I think we're going out around in circles.
Yeah.
I've made the point, my lord, that if there's direct discrimination, as I submit there is, and it's on a listed ground, and it's presumed to be unfair, the state must show, as part of discharging the onus to prove that its conduct is not unfair, that it could not make reasonable accommodation. And we have shown empirically that if the allowances were given of 50 people to masjids, limited to 20, it doesn't matter. At least prayer is maintained. The community exercises its religious duty to keep the mosque running. We've indicated in our papers that the duty to establish congregational salah in a masjid is a communal duty. In other words, the failure on the part of the community to fulfill this obligation renders the community as a collective sinful and accountable to God. This is at 218, paragraph 18 of our founding affidavit. So in Islam, I'm not sure about other religions, you have what is called, and your lordship may be aware of the terminology, farad kifaya and farad ain obligation. So you have certain obligations on an individual and certain obligations of the whole community. If the community obligation is not fulfilled, the entire community is sinful. And one of those communal obligations is to establish the 5 daily prayers in a masjid. No one in Islam has jurisdiction to close a masjid. It is the house of God. The Quran, in fact, says emphatically that there cannot be a greater form of oppression to prevent a person from praying and remembering God in God's house. That is emphatically part of the religion. There is a verse of the Quran which says that expressly in so many words. We consider, my Lord, this intrusion of our religious rights as a form of oppression. And that is our case, my Lord. And I think, with respect, I've debated this ad nauseum. We're going forward, up and down on the same point. I can't take it further, my Lord. I think I've made my submissions to the best of my ability on the issues that your lordship wants me to address.
What do you say you consider the intrusion of the religious rights as oppression?
Oppression. So it's a form of oppression. The Quran is expressed on that, my Lord. I can read the Arabic, but it talks about churches, mosques, synagogues, all of them. Who can be a greater oppressor than one who prevents a person from remembering the word of God in churches, mosques, synagogues? There's a verse of the Quran which is exactly that. Sorry, my Lord, I just want to see something.
Yes, I think your time is up.
Sorry, my Lord, I just want to draw your lordship's attention to a passage in Esau, paragraph 79, where the court says that the implementation of legislation, which includes the making of a regulation in terms of an empowering provision, is therefore not excluded from the definition of administrative action. So it's not a matter of policy, my Lord, it's a matter of implementation of legislation. Yeah, my Lord, I think my learned friends previously dealt with mootness. There are clearly live issues, whether this is executive or administrative action, what the duties of the minister are. I think those require your lordship to pronounce on them. I'm not going to say anything further about that one. Unless there's anything else, my Lord?
Mootness, this is the question only on mootness. If she made the decision on specific set of facts at the time, and the next time she's making the same decision but on different facts, then isn't the first one moot?
No, because there are policy issues.
But now you just told me that they're not policy, they're admin issues.
No, so the minister says when I'm doing this, I'm performing an executive function. And if she's wrong, then her duties and the approach to her duties.
Issues, it's a different thing.
Sorry, my Lord?
Principled issues, it's a different.
There are principal issues that
not
require.
Policy issues, but principled issues.
There are principal.
Issues of principle.
There are issues of principle, my Lord.
Yes, that's what you mean when you say there are policy issues.
Yes, principle issues. So for example, if your lordship were to find that this is executive action, then that will inform the parties' rights, everybody's rights and obligations in future regulations, and obviously they'll be limited to those rights attached to that particular aspect.
Yes, but we still stick to the mootness point, even on the principles point. So can we can we breach certain principles? Is principle not flexible enough, rather? Is principles not flexible enough to cater for different circumstances? So in
My
the
Lord, we've
circumstances of this, I breached your, on principles, I took a decision that breached the principle, but on others, I will not breach the principle. In other words, the facts have changed.
My Lord, we've dealt with mootness in our heads quite comprehensively.
Yes, what you've said there, and I was a bit, you've said there that you've relied a lot on some of the labor law cases, and you've said there that there's interest of justice requires that the court makes a decision because it may have a future impact upon people's rights and give guidance to people as to how they must conduct their affairs in future.
It's not only labor cases, my Lord. There's a whole lot of
Okay, Mr. Boda, it was more than labor
and then
cases.
Isao, my Lord.
All right, Mr. Boda, it was more than labor cases.
It's not only labor cases. Isao dealt with this. I think my learned friend, Ms. Engelbrecht, referred you to Isao.
Yes.
And said that the oscillation between the various alert levels means that issues arising out of regulations published under the Disaster Management Act do not readily become moot. And that's your Lordship's point addressed right there, my Lord.
And Esau, which one?
Isao, my Lord.
Paragraph?
Sorry, I don't have a paragraph, but the footnote is footnote 5 of our heads of argument. I will get the paragraph now, my Lord. I'll just ask one of my juniors to send you the paragraph number. I think Ms. Engelbrecht did refer that to you.
Thank you, Mr. Boda.
As a court, please.
Okay, Mr. Boda, none of the parties are seeking costs, am I right?
No.
Or you don't know?
No, my Lord, we're not seeking costs. We're all pro-amico, my Lord. I think all of us are acting pro-amico, most of us.
Okay, thank you then, Mr. Boda. We have exceeded our time periods. We're now at 11:30. Can we adjourn for a few minutes, Mr. Botha?
Yes, please, my Lord. I was going to ask your Lordship for a brief indulgence for a few minutes, and then we can carry on from then if it suits your Lordship.
Right, so we start at 12:45. We'll finish at 1:45. We'll break for lunch at 1:45.
My Lord, I may be a bit longer than that, given the questions your Lordship has raised. I'll need a little bit more time to address some of the aspects.
Maybe I was a bit more interventionist with Mr. Boda because I thought he was the most senior. He should answer some of those questions. But you're more than welcome to compliment his submissions.
Thank you.
But I hope not to be as interventionist. Can I say then what we do, Mr. Mugagabe will then start either at 1:15 or 1:30, because after the lunch break. I would presume he'd be for most of the afternoon.
Indeed so, my Lord, and he probably go until tomorrow, we would assume, my Lord.
You think so? You don't think we could finish it this evening?
We don't mind working later this evening. We are at your Lordship's disposal. We appreciate your Lordship
being into that situation today and come back to me
as your Lordship,
at the after the lunchtime break.
As your Lordship, please.
You needed to still sit tomorrow or not?
I think it's inevitable, but I'll confirm with my colleagues.
Okay.
As your Lordship pleases.
Mr. Mugagabe, can we then adjourn?
As the court pleases, my Lord.
Right, and then you'll be ready after lunch.
Hopefully so, my Lord. Depends how soon is Mr. Botha will obviously complete his submissions.
As your
Lordship pleases. I said we can compliment, hopefully not repeat what was said. Yes. Okay. Thanks then.
As long as it doesn't overlap, my Lord, then we will maybe finishing.
Yes, as long as it doesn't repeat a lot.
Yes.
Okay.
Not a repetition.
As your Lordship pleases. There's no intent to repeat anything, my Lord. Thank you.
Right.
so, my lord. I haven't done a roll call, but it looks like it.
Okay, Mr. Botha, let's hear your submissions. You say you're going to be dealing with justification, facts and law only. Botha, I don't have yours. Oh, yes. Oh, I see you're going to deal with mootness, absence of record, fundamental rights, absence of justification, essential service workers.
And consultation.
And absence of consultation.
Indeed, sir, my lord. So I'm still going to deal with exactly those topics. What I've done, I've noted, obviously, your lordship's questions and interactions with my learned friends. In engaging with my learned friends, your lordship engaged with a number of topics, both directly and indirectly, that I was to address. So I won't repeat, but I will have to deal with those questions that your lordship has posed, because that was always part of what I was going to argue. I have reconstructed my argument, and I'll give your lordship my roadmap in a moment. But the consequence is that there are two consequences. I'd initially intended my argument to be briefer, and it is going to take me longer, because I've noted from some of the questions your lordship has posed that I'm going to need to take your lordship to both the facts and the authorities in more detail than I'd initially hoped. And I'm going to have to take your lordship to them in some detail. I'll endeavour to do it as briefly as possible nonetheless, but I'm going to have to work through it. I see Mr. Mokhagabe was outside. He's now back.
My lord.
I'm sorry. I would never have started if I'd known you were not in, Mr.
Yeah, I had difficulty, connecting, my lord.
I'm sorry.
Yes.
Can any of your juniors or others, if they know somebody is out or somebody's, can they please put their hand up? Because otherwise we'll be making an assumption.
Yes.
Boitumelo, can you please keep a note of who is, if someone is not in? Because we shouldn't have that situation where we have submissions taken in the absence of a party, especially of lead counsel. All we got is Mr. Botha just spelling out his roadmap.
Yes, Judge.
He hasn't started with his submissions at all. He said he might have to repeat now and again, but he'll try to avoid it. That's about what he said. And he's still sticking to the roadmap that was set out in the document they gave us yesterday morning.
Yes.
Okay, so
What my lord, if I may be allowed to, to address the court, is that since there's a pattern which has evolved, when the council are addressing the court, because they seem to veer outside, the topics which they have delineated as to which party is going to argue. And secondly, I thought there was an agreement yesterday that there won't be a repeat or overlap, by the parties regarding these arguments.
No, there won't be before. I'm going to deal with it as, and if I may answer through your lordship, my learned friend. A lot of the engagement, as I was explaining, and my learned friend was absent, and I apologize. I didn't know he was absent. I saw his team. I assumed he was there too. My apologies, my lord. But what is very clear, my lord, is that a lot of the questions your lordship asked, of course, engaged topics that I was going to deal with, and I still need to deal with those, and I'm going to stick to the topics I'm going to deal with. But the consequences I was explaining to your lordship is I may be a little bit longer, and I'm going to have to just deal with it in somewhat more depth. And there's another reason, my lord, why, with respect, I'm going to ask your lordship's brief indulgence. I'm going to exceed. Oh, your lordship's left.
Okay, I'll call Judge.
Thank you.
am I back?
Your lordship is back.
I'm not sure whether Senior Counsel Mokgakabe has logged off as well, or is he still here? Oh, he's here. Okay, Judge.
Thank you, my lord. I was just explaining, my lord, I might be slightly longer, and I was about to request another, or give your lordship a second reason why I may have to exceed the hour initially allocated, and that is, as my learned friend Mr. Botha so aptly illustrated, with reference to religious freedom in respect of Muslims, who and we as freedom of religion represent a very broad base. Your lordship would have noted the passion and the importance of religious freedom. This judgment that your lordship is going to give is not just about the Disaster Management Act. For instance, if your lordship finds that religion is subservient to economic rights, that will have a fundamental ground-changing effect on the exercise of religious freedoms for decades to come, my lord. So, yes, there is always an appeal, but the point is that your lordship is the one who's going to determine these issues, and they are very, very important issues. And these considerations, such as where religious freedom is balanced and where it finds its place in the structure of the Constitution, cannot be overstated. And if I do not do the parties whom I represent, my lord, which are in the millions, there are millions of people which constitute the constituency of 4SA, and we're representing today. If I do not do that justice just by simply making haste, as is sometimes my want, my lord, I would be doing them a disservice. So if your lordship will indulge me. What I'm going to do, my lord, is I'm going to address a number of topics. First of all, I'm just going to deal with, this is not a state of emergency. And that picks up, it doesn't overlap, it just picks up and complements what my learned friend Mr. Botha has submitted, and in regard to the policy issue, which I will address separately. The next topic I will deal with is what I've framed, how we worship. I'm going to deal with that, and I'm going to set out for your lordship what religious rights and freedoms mean, what they mean for the constituency that I represent, those millions of people that I've told your lordship about, and what exactly they believe and where worship fits in that hierarchy. I'm then going to address, it's an element of justification, but it's certainly an element that your lordship has raised again and again, economy and religion. Now, it's something we traversed at length in our papers. There's a slight overlap on the facts with SANCF, but I'm going to illustrate to your lordship how the various submissions that Ms. Martin made actually fit together. And I'm not going to retraverse the ground that she's traversed, but I'm going to explain to your lordship, or endeavor to make submissions to your lordship, as to how these two fit together in the religious context that I represent, and why there is the issue around economy and religion is actually a red herring, and in any event is not a point that the minister was so bold to make. It's very important to remember that in these papers, your lordship has raised the issue with us. This is not an argument that the minister makes. The minister doesn't say the economy is more important than religion. She wasn't bold enough to make that statement, my lord, because with respect, it would be fundamentally flawed, as I'll seek to demonstrate to your lordship, and as with respect Mr. Botha so passionately and eloquently already demonstrated. I'm then going to deal, my lord, with the rationality examples. Why am I dealing with this? Because that is the central issue in our papers. The only evidence that there was any kind of difficulty in respect of religious gatherings is addressed in our papers. And there's three anecdotal examples. I'm going to deal with that, and I'm going to deal with the detail around this balancing between the two examples. That, of course, goes into the justification. I'm going to briefly deal with mootness. Why am I going to deal with mootness? Because your lordship had the debate yesterday about the supplementary affidavits. As part of that, I'm going to address the topic of judicial notice, and I'm going to explain to your lordship what our case is as far as judicial notice. Although the affidavits are not there, and your lordship has posed a question about a set of facts in one timeline and a set of facts in another, and whether that isn't moot on itself, I'm going to address that with reference to the government gazettes on that basis. Lord, I'm then going to deal with the polycentric approach and section 36 and how those two fit together. In particular, I will deal with SL, which we respectfully submit is now the binding authority of the Supreme Court of Appeal, the Constitutional Court not having dealt with these regulations as yet, and in particular in that context. I'm then going to deal with two further topics, which is consultation. My Lord, there is a very clear difference between the issues raised with the consultation as regards my learned friend Ms. Martin's case and the 4SA case. And I'll demonstrate to your Lordship what those are and the case we made out in the papers. But one of the questions your Lordship posed to my learned friend was, how do you test? What is the test to decide who to consult with or not? And I'm going to give your Lordship that with reference to the Supreme Court of Appeal authorities, amongst others, in the Scalabrini case, a judgment of His Lordship Mr. Justice Nugent, which is then followed in a further Supreme Court of Appeal case. Finally, I'm going to deal with essential service workers, my Lord. That's actually a very narrow issue, very simple issue. I've taken note of your Lordship having sat on the panel that decides, or chaired that panel of essential service workers. It's a simple interpretive argument, and I'll show your Lordship with reference to Annex D to the regulations that the Minister is not usurping any powers. What she does is she uses that essential services legislation as one of the grounds for essential service workers under Section 213 of the Labour Relations Act, which your Lordship will of course be very au fait with. But she says as listed below. And so it's a very simple point that we raise there, that on a plain interpretation she has every power. And in any event, the President gave a promise that religious workers were going to get essential service workers. He even said it in a speech. And therefore, there can be no rational basis for suggesting why they haven't been included. And then finally, I'll just briefly deal with the relief, which touches on some of the confusion yesterday in the interlocutory argument between my learned friend, Mr. Willis, and Mr. Mokgakgabe. Without further ado, my Lord, if I can start then with this is not a state of emergency. And I would refer your Lordship, because it is set out in great detail in our founding affidavit. It commences at 001-15. What we're going to endeavour to do, my Lord, is we're going to use case lines and to take your Lordship to the relevant pages.
Just a minute, I need to get your case because I have to get a different party's case.
As your Lordship pleases.
The cases haven't been put together in case lines.
No, they haven't, my Lord. They are consolidated, but they're still separate cases. My Lord, as I understand the law on consolidation with respect to my learned friend Ms. Engelbrecht dealt with this issue. Although cases are consolidated, their facts aren't. And so the law, when you look at the law on consolidation in the Uniform Rules of Court, we still have separate papers and separate matters. So your Lordship would still do the judgment, but by convenience, what happens is you consolidate them because they have similar issues. So that's how I understand the legal position, and that's why you don't just bundle them all together as I understand it, my Lord. Has your Lordship managed to locate our case?
Not yet.
It would be under Freedom of Religion South Africa. So I don't know if your Lordship is listed alphabetically, and your Lordship's probably got thousands of cases in your case.
Especially when you sit in unopposed motion.
Yes, I know, it must be absolute chaos.
It just accumulates.
Perhaps your Lordship searches Freedom.
What is the case number?
I can give your Lordship the case number in a few seconds. It's 2619/2021.
2619.
2619/2021. Your Lordship managed to locate it?
There's another whole load. I'm going to try some other thing. I had it earlier. You see, there's another thing.
If your Lordship has your Lordship's case list and your Lordship puts in text, if your Lordship searches Freedom, it should locate the case. It does that for me if I do that.
Followed the example and it came. I'm there.
As your Lordship pleases. So, my Lord, if I can ask then Learned Junior Mr. Crompton, will just redirect your Lordship to 001-15. In fact, I've done it. So, my Lord, this is in the founding affidavit, and the point we simply make in the founding affidavit is this. This is not a state of disaster. I'm going to deal with this under another topic that Your Lordship, which I'm required to address, and that Your Lordship raised with one of my learned friends. But what the real issue here is, my Lord, under it, you've got two different forms of legislation, and this was dealt with again recently in the AfriForum case against the Minister of Tourism. That case we've also uploaded, my Lord, to case lines in the meanwhile, and I'll take Your Lordship to it in due course. But what you've got to do is the minister has chosen, or the government has chosen, a set of legislation, and they have, instead of using a state of emergency, for instance, as we explain, it is not declared a state of emergency and at paragraph 9. But what I'm going to point out to Your Lordship, and as is made very clear in the founding affidavit, is even if they had chosen a state of emergency, that does not allow them to derogate from certain fundamental rights. The point we make at 001-16, in contrast to paragraph 10, my Lord, in contrast to the present situation where the national state of disaster is simply being extended by regulation of the minister in terms of section 27.5c. And it's been going on for months now, my Lord. It's in excess of 18 months. It's been since 13 January 2021. That could be no more effective in a state of emergency for more than 21 days from the date of declaration. So the National Assembly is supposed to extend these things. Now, the present, where you did the affidavit, was in existence for 10 months. Now, what else section 37.4 of the Constitution allows is that any legislation acted in consequence of a declaration of a state of emergency, I'm now reading at page 17, my Lord, paragraph 12, is that may derogate from the Bill of Rights only to the extent that the derogation is strictly required by the emergency, and B, the legislation is consistent with the Republic's obligations under international law applicable to states of emergency. So again, I'm going to highlight international law and foreign law in my argument, conforms to subsection 5, and is published in the National Government Gazette as soon as reasonably possible after being enacted. Further importantly, under section 37.5 of the Constitution precludes any derogation from section 37 and any derogation from the sections mentioned in column 1 of the table of non-derogable rights to the extent indicated opposite that section in column 3 of the table. The table includes section 9 in respect of equality with respect to unfair discrimination solely on the grounds of, amongst other things, religion. The table also lists other non-derogable rights that are directly implicated in the exercise of religious freedom, such as those in section 10, human dignity, and section 12, freedom and security of this person. My Lord, in that context, we submit at paragraph 14 that it cannot be that in terms of the impugned regulations, the minister can go further than she would if we declared a state of emergency. We all know the history of states of emergency in this country and how unlawful and irrational they were. Now, that's what section 37 says. It complements the argument that my learned friend Mr. Botha made when saying that with reference to Harkson and Lane, you cannot simply derogate from rights, and especially protected rights. So there's another case, my Lord, a recent case of the Constitutional Court 2014. It's SALI, S-A-L-I, versus National Commissioner of the South African Police Service, 2014 JDR 1186CC. Para 7 to 12, they conveniently summarize the law. And there it was an issue to deal with. Sorry, my Lord?
SALI was
National Commissioner of South African Police Service. His Lordship, Mr. Justice Jafta, at paragraph 7 to 12, deals with the issue that confronts your Lordship here. Says it's significant, he says, to note that the Constitution lists a number of grounds on which the state is precluded from discriminating unfairly against anyone, and those grounds include age. Notably, the Constitution does not rank discrimination on the basis of race or gender higher than discrimination on any of the other listed grounds. This means that discrimination on any of the listed grounds must be treated seriously. It is apparent from section 9.5 that discrimination based on any of the listed grounds is presumed to be unfair. The claimant need not prove unfairness. Instead, it is the person who wishes to defend the discrimination who must show that it is fair. The test for determining whether a claim based on unfair discrimination should succeed was laid down in Harkson, and my learned friend read the section. I'm not going to repeat. He then goes on, His Lordship Mr. Justice Jafta, at paragraph 10 to say, although the test was formulated with reference to a claim in which the constitutional validity of legislation was impugned with the necessary adjustments, it may be applied where the attack is directed at conduct, policy, or practice. What needs to be established at the commencement of the inquiry is whether the policy or practice on which the challenge decision was based differentiates between people. If it does, whether the differentiation bears a rational connection to a legitimate government purpose. If it does, the policy or practice may or may not, depending on the circumstances of a particular case, violate section 9.3 of the Constitution. Where there is a rational connection between the impugned policy or practice and a legitimate government purpose, it is necessary to inquire whether the differentiation concerned amounts to discrimination. If the differentiation was based on one of the grounds listed in section 9.3, it is presumed to constitute discrimination, which is further presumed to be unfair. This means that an applicant needs only to show that the differentiation complained of was based on a listed ground for the double presumption to be triggered. So, my Lord, at the end of the day, we submit that there is a double presumption in favor of the religious community here, which far outweighs any presumption that, or any other right, including a right to the economic interest, the pecuniary interest, as your Lordship had debated with my learned friend, Mr. Botha, and that those are actually secondary to these rights. So I'm now going to deal, my Lord, with the next topic, having framed the debate of how we worship. Your Lordship raised
in your opinion, where is the discrimination? There's a prohibition on faith-based gatherings. So why are they discriminating when you say a differentiation between people?
Yes, my Lord. So yes.
One thing we know is not a differentiation within faith-based communities, because it's in across the board, all faith-based communities.
All faith-based communities.
So there's no discrimination within them. So now it's between them and who?
Anybody who's not practicing their faith. Now, your Lordship put a question, I can't remember to which colleague, but your Lordship framed it thus, to say that, but the regulations would allow you, because your Lordship seemed to suggest there was a differentiation, the regulations would allow you to go to the restaurant and to pray. Lord, with respect, the minister says, no, you can't. So what happens? I go to a restaurant, and she says this expressly under oath, and I'll deal with this under the rationality part in a moment. But she says it under oath, my Lord. So what happens is if I go to a restaurant and I pull out my Bible, all of a sudden, I'm no longer allowed to do that. That, the minister says, will break the law. Your Lordship is frozen. I don't know if your Lordship can still hear me.
I can hear you very clearly.
Thank you, my Lord.
I can hear you very, very clearly.
So, my Lord, so there is no, this is just one example, and I'm going to give your Lordship a lot of other examples under the rationality test. But here, you're distinguishing between a religious person attending a restaurant and any other citizen. Because a religious...
Once you attend a restaurant and you engage in economic activity as well as religious activity. That was my
that was your Lordship's point.
Yes.
But the minister says your Lordship's wrong. The minister says that you can't do that and it's illegal, and I'll give your Lordship the references when I get to that point. She says that would be illegal. At the moment when you suddenly start, if I get together with my family, and this is what most religious people do, we pray before we eat. And we suddenly, if we start sharing scripture around the table, and we're now gathering around those things, and let's say I gather with other friends. As long as I stay off the religious grounds, the minister says that's a perfectly legal engagement. But she says, if I start making it a religious gathering, it would be illegal. Those are her words, not mine, my lord. It's her interpretation of the very regulations she's promulgated. If that's not discrimination on the grounds of religion, I find it very difficult to find an example that is stronger than that. Now, my lord, you can also go to a number of different places. You can go and gamble. You can go to a restaurant. You can do all these things, but you cannot exercise your religion. That is clear discrimination on religious grounds, on the facts, on the minister's own version.
Give me an affidavit where she refers that to.
Lord, if you'll just bear with me. I was going to deal with that a little bit later. I'll just find the example in a moment.
Okay, then just remember to bring it to my attention.
I will bring it to your Lord's attention. It's definitely that. I'll ask somebody in my team to just find it in the meanwhile. Lord, it is in our heads as well. It's amongst, unfortunately, I've got a lengthy page of notes, but I'll definitely get there. And if not, somebody will send me the note shortly, my Lord. As regards the exercise of the religion, my Lord, what we are going to submit, my Lord, is that your Lordship said something else. Your Lordship put two propositions. And then your Lordship mentioned that you would put a third proposition, but I don't think your Lordship has put it yet. So, but the two proposition is this: isn't prayer more important? People can pray in their homes. That was the one proposition your Lordship put. And the other proposition that your Lordship put was ban is only temporary. I'm going to address those in the course of this argument, my Lord, but both of those go to exactly how people worship. Lord, if I may just give your Lordship the reference, the minister's affidavit is at 009-32 at paragraph 122. And I'll find it in our heads of argument in a moment, my Lord. It's at footnote 22 at 054-9 in our heads. Here's the context. In the founding affidavit, we said the following at para 217, which is 001-105. I think what we should do is take your Lordship there. Take your Lordship there momentarily. I'm directing, yes, to the page 105. We said at paragraph 217 that opponent says the irrationality, it's at the bottom of the page, of the regulations is also demonstrated by the fact that congregants could meet in a restaurant or conference venue and conduct their service perfectly legally, but they cannot do so legally in a religious building specifically designed for the purpose. That was our statement. The minister responded to that statement at paragraph 122, 009-32. Sure, my learned friend will take you there shortly, my Lord. But she responds, your Lordship will see a paragraph 122. Is your Lordship there?
Yes.
She says, I deny the regulations are irrational. All gatherings remain prohibited, and the holding of faith-based gatherings at restaurants or conference facility I assume she means will be, an offence in terms of the regulation. Now, it can't be clearer.
See, there's a slightly difference between those two statements and the one I'm putting forward. I'm saying that if you're engaging in economic activity, that's the example I put. You purchase coffees, you're paying for something that then in the course of that you also, or during the course of that or whatever, or complementing that, you also do what you pointed out about at the dinner table, what people do. You cannot be seen to be breaking the regulations because it's economic activity supplemented with. But this is what your paragraph 217 is talking of meeting in the place and using the place exclusively for religious activity.
That was never the intention, but let's assume that is correct. My Lord,
And that's how I read it, and I'm sure I would assume that's how she read it. And she says, all gatherings in the hearing of whole and cold, it's not very well written, all gatherings remain, all religious, all faith-based gatherings are prohibited. So her 217 is slightly wrong. She shouldn't be saying all gatherings remain prohibited, because you are allowed to gather in a restaurant for economic, when there's economic activity taking place. So it's all faith-based gatherings remain prohibited. So if you're meeting there for faith-based gatherings, not for anything else, then she would be correct. So she must have read you to mean meeting in the restaurant. In other words, it's just a location, it's just a venue.
Lord, let's assume, and nobody would go to a restaurant without paying for some food or renting the venue. There's an economic transaction. So I respectfully submit Your Lordship's interpretation is a bit narrow, but more particularly, even if that were so, on that reasoning, my Lord, where you have churches with coffee shops, which is a common occurrence, what Your Lordship is saying, you can't go to the church and have a cup of coffee either. But what they did is they banned you even doing that. And in fact, the regulations go so far as to say that you can't have coffee after church. Now, those coffee shops also charge money, and there is an economic transaction that takes place. The rationality, my Lord, is palpable. And what you're just doing is you're saying, if there's economics, it trumps your religious rights. That's firstly Your Lordship's proposition, seems to be Your Lordship's position, which I'm going to address further. But more importantly, it's irrational, because what you're saying is if I have a cup of coffee, I can pray. But if I don't have a cup of coffee, I can't pray. Lord, there's no rational connection between those two. And I'll show Your Lordship how His Lordship Mr. Justice Plaskett dealt with this kind of situation in the Esau judgment, and how what the rationality test in fact is. And there needs to be a proper basis, and the minister needs to give what that basis is. But I will come there, my Lord. So dealing with, firstly, the religious right and how people worship. Your Lordship is with respect saying, when Your Lordship says that we can, surely prayer is the most important and people don't need to gather. Your Lordship with respect is making exactly the same mistake that the minister makes. What the minister tells people to do is how they must worship. And that Your Lordship will find at 009-16, paragraphs 38 and 39. I know Your Lordship's being directed there, but what it says is, the regulations do not interfere with religious convictions and beliefs. They merely temporarily prohibit faith-based gatherings in a physical setting. Where there are holy texts, she tells us, she knows the Bible, my Lord, that command people to gather, it must be that these texts or scriptures envisage exceptions to the rule in situations where it's not safe for people to gather. Lord, with respect, that's the same presumption Your Lordship appears to make. But that's not what the holy texts say. Our response, my Lord, you'll find at 010-42, paragraph 82.
Just refer me to it.
010-42, paragraph 82. Is Your Lordship there yet?
I'm there.
Thank you, my Lord. Your Lordship will see that what it says is in response. It says it's fundamental to many beliefs, including that of Christians, Muslims, and Jewish people. Your Lordship's heard from my learned friend, Mr. Botha, that they must gather physically. It is not for the Cogta minister to suggest how these scriptures should be interpreted. She's neither an expert in the field nor otherwise qualified to do so. It's not even for the court to interpret these provisions, as it would contradict the well-established doctrine of non-entanglement. And I'm going to take Your Lordship there in a moment. In any event, as stated in my founding affidavit, the scripture not to forsake the gathering of the saints in Hebrews 10, verse 25, was written exactly in a time when it was unsafe for believers to gather, precisely because they would be persecuted in the form of threat to their lives and their goods. My Lord, that passage of scripture To give your lordship the context, and this is why it's dangerous for the minister to be presumptuous and to say things like she said, and that's why the courts don't interfere with that. The simple text in the simple passage, it says at verse 24, let us consider how to stir up one another to love and good works, not neglecting to meet together as is the habit of some, but encouraging one another, and all the more as you see the day drawing near. What you'll see later, my lord, in verse 33, it says you will be punished. These are things that are going to happen. And it says in verse 34, for you had compassion on those in prison, and you joyfully accepted the plundering of your property, since you knew that you yourselves had a better possession and an abiding one. The context of that scripture is that by helping others and visiting people in prison, they were arrested. They were told that if they gathered together, they would be arrested. Nonetheless, the Apostle Paul writes to the Hebrew church, and he says to them,
what are you reading from?
I'm reading, my lord, from the scriptures. But the founding affidavit refers to Hebrews 10, verse 25, and all I'm giving your lordship is the context. And that is why it is very dangerous for the minister to presume how people should conduct their religious activities. She cannot dictate, the law says, and I'm going to take your lordship there now, as we say in paragraph 80.4, how they should express their faith. She can't do that. That's the fundamental difference between the separation of church and state. The main issue is that there are less restrictive means, and this is the section 36 inquiry, my lord. This is where it comes down to. There are less restrictive means to achieve the purpose of the DMA and the regulations, as far as the purpose is to slow the spread of the pandemic and to save lives in a manner that does not unduly infringe fundamental rights. I want to leave your lordship with that. That can be no other purpose. That's what SR says. That's the purpose of the regulations. That's what they themselves say. They've got to slow the spread of the pandemic. What they've got to do is they've got to deal with it, and they've got to save lives in a manner that doesn't unduly infringe fundamental rights, my lord. That's what we respectfully submit, the definition and the purpose that you've got to read in the DMA. Now, if your lordship has regard to what the submission I've just made, we've uploaded a case, a judgment by his lordship, Mr. Justice Ponnen, in the Supreme Court of Appeal, paragraph 39. It's the matter of De Lange, give your lordship this full citation, De Lange versus Presiding Bishop, Methodist Church of Southern Africa and another. 2015, Volume 1, South African Law Reports, 106 SCA. It is also been uploaded, my lord, in case lines, and your lordship, I'm directing your lordship to the page as we speak. It's at 0052273. At paragraph 39 of that judgment, it tells your lordship in dealing with these matters, it's the principle of non-entanglement. It's not it's a foreign court principle as well, international principle. Courts do not interfere with the beliefs of people, nor do they dictate what they should believe, because that's a fundamental interference with their religious freedom. So at paragraph 39, it said, I've directed your lordship to the page, as the main dispute in the instant matter concerns the internal rules adopted by the church. Such a dispute, as far as is possible, should be left to the church to be determined domestically without interference from a court. A court should only become involved in a dispute of this kind where it's strictly necessary for it to do so. Even then, it should refrain from determining doctrinal issues in order to avoid entanglement. It would thus seem that a proper respect for freedom of religion precludes our courts from pronouncing on matters of religious doctrine, which falls within the exclusive realm of the church. So it's not with respect for the minister, or indeed for your lordship, to tell religious people how they should exercise their religion and what is appropriate and what is not. Otherwise, you negate the very basis of religious freedom. So, my Lord, brings us to the Constitution. I'm arguing this all in the context of what does this fundamental religious right entail? What does it mean to have the freedom of religion when it is spoken about so eloquently in the Constitution?
Well, can I ask you this question on this?
Yes, ma'am.
If she was to say, I'm allowing it with restrictions, as she's now saying, is she interfering with their rights on how to practice their religion?
She is, my lord, but she's doing so on a rational and legal basis based on the Section 36 test of the Constitution.
And you're saying in the second scenario, she passes the Section 36 test?
She does.
In the first one?
Not in the first one. And that's really the difference. So all the examples, my lord, and perhaps it's appropriate I contextualize this for your lordship now. What she has to show under section 36, and bearing in mind the double threshold test, what the minister has to show is that gathering as a church or for religious purposes or a faith-based gathering is somehow more dangerous than sitting in a taxi, sitting in a restaurant.
Is she saying that, or is she simply saying, I reluctantly have to, and you're saying I'm making this case for, I reluctantly have to concede to one practice because of the need, the necessity for people to do what's necessary to earn their living.
I mean,
in other words, they have to travel from one place to another on a daily basis,
yes,
and to get onto their work so that they can put food on the table.
Yes, my lord, that may be so, and they're exercising their right under section 22 of the Constitution. And I'm going to show you, lordship, that in a moment.
Is that the one dealing with the right to practice your trade?
Freedom of trade, for instance. Many would be exercising,
etc.
Exactly. But that's one right. Now, the question is that right a non-derogable right? No, it isn't. So if you can make an exception for that right, and this is where all of the rationality arguments go, there's no reason why you cannot make an exception, and indeed you must make an exception for a far more important right. And I say that without hesitation, because that's what the Constitution says. So what you're doing is you're discriminating against somebody on the grounds of religion, which is a non-derogable right. So what she'd need to do, the Lord, to pass the rationality test is to say, and I'm going to show your lordship some further examples of the difficulty with the rationality here, because in the early part of the pandemic, from May onwards, June through July, what happened is religious meetings, religious gatherings were permitted, but you couldn't go to a restaurant. That's the minister's fatal flaw. I'll show you, lordship, that in her answering affidavit. She says in the Part A answering affidavit, religious gatherings couldn't meet. What are you moaning about? You couldn't previously meet. They could. And then later she opens restaurants and gyms. Now, having done that, how can she rationally suggest that there's a change of circumstances without giving your lordship the facts? It's not a policy issue. It cannot be, because she hasn't said so. She hasn't relied on the economy. She has to give a rational reason for the change in circumstances. Absent such rational reason, her conduct must be irrational. More so, where you're dealing with a fundamental human right to worship. As my learned friend Mr. Botha so eloquently explained it, given his own personal circumstances. But what does the Constitution give us? And this is important, my lord. The Constitution gives us at section 15, sub 1, everyone has the right to freedom of conscience, religion, thought, belief, and opinion. But it doesn't end there, because we also have section 31. And insofar as your lordship suggested that you can't gather because you must pray in quiet, with respect, the Constitution says something else. It says section 31(1) says persons belonging to a cultural, religious, or linguistic community, a community, my lord, may not be denied the right with other members of that community, cannot be clearer, to enjoy their culture, practice their religion, and use their language. Lord, it is inherent in the Constitution that I can gather together with other congregants who believe, like I do, that Hebrews 10 verse 25 says that I'm not to neglect the gathering together of the saints, as some do. And especially when the evil day approaches, they believe those things. As my learned friend, Mr. Botha, explained, Muslims believe exactly the same thing. So in those circumstances, section 31(1) is a right that is afforded to everybody who is a member of a religious community to gather with that community and practice their religion. Now, it does say in subsection 2 that the rights in subsection 1 may not be exercised in a manner inconsistent with any provision of the Bill of Rights. But what the minister doesn't do is she doesn't come to your lordship and say, you gathering is gathering in contradiction with another right, in the Bill of Rights. She doesn't make out that case. And your lordship may seek to make out that case for her, but with respect, you cannot. That's with how these papers work. That's how court proceedings work, my lord. We have papers. I'm going to refer your lordship to the law on judicial notice. There's certain things your lordship can take judicial notice of. There's certain things your lordship, with respect, cannot. In the first matter, which ultimately went to the Supreme Court of Appeal and they lost horribly, my lord, there were two matters. There was the Muhammad judgment, and then there was the judgment, I forget the name now, off the top of my head, Liberty Fighters, my lord, matter. And what happened is the learned judge in that matter overstepped.
The beer matter. Indeed,
my lord, De Beer. And what happened is the learned judge overstepped the mark by taking into account things and making out cases for the parties that was not supposed, they didn't themselves make out. And that's why the matter failed on appeal. Whatever the judge's personal convictions about the matter were, my lord, is inappropriate. And that's why the matter was overturned on appeal. Your lordship has got to deal with what is in front of your lordship. And there are various limits to which one can take judicial notice of matters, and various limits to which one can make certain assumptions. My learned friend, Mr. Botha, read to your lordship from the Nicro case. There's a very narrow differentiation between what is common sense and what is fact-based. But where your policy is vacillating, as here, one, we submit it can't be a policy, and two, you have to rely on facts to support the so-called policy because of what they say on their own version. So, my lord, the fundamental rights that are afforded to religious people are in section 15 and section 31. And those go together with section 9. I'm not going to read it. Your lordship's well aware of it, and I've referred your lordship to the judgment. Section 10, that deals with dignity. And in particular there, my lord, arrested persons. Now, what's important, I'm going to show your lordship the government gazettes that we put up. Your lordship's frozen. I trust your lordship can still hear me.
I'm here. I can hear you absolutely clearly.
I'm very glad, my lord. So what your lordship will see is that the gathering together in the latest regulations, the minister has upped the ante. She's made it a criminal offence. Previously, under the prior regulations, you could gather, the police had to come and say, break up your gathering, and then only if you refuse to break up the gathering could you be arrested. Now, under the new regulations, even having a gathering of a religious person amounts to an immediate criminal offence, and you're liable to arrest and conviction.
You're referring to the December, January.
What happened in the December, January, the ones we are attacking, my lord.
Yeah.
Those particular regulations, the police could break you up first. They had to tell you, break up your religious gathering, and then only if you refuse could they arrest you. Now, actually meeting is criminalizing it. Now that goes to the mootness.
Regulation is that?
That, my lord, you'll find in the supplementary affidavit, which we put up. I'll reference your lordship in a moment. It's our further supplementary was the July one that was debated. We've abandoned putting it in, my lord, but the regulations themselves are before your lordship. And you'll find them, they're DZ1 and DZ2. I'm directing your lordship to the page. It's 011366. And your lordship will see in the 27 June regulation and the subsequent 11 July regulation, which your lordship finds at 011-390. In those two regulations, she's now criminalized meat gathering for religious purposes. In those circumstances, my lord, it can hardly be suggested that this case is moot. But I was addressing this point in a different topic. I was addressing the topic on the basis that, in fact, my lord, I'm going to direct your lordship to the page to demonstrate to your lordship the 11 July one.
Can you just give me a second to read this one first?
So 011395, that's the 11 July Gazette.
Can you just give me a second to go through that? Yes.
Your lordship will see at 395, at subparagraph 19, a convener of a faith-based religious, social, political, or cultural gathering who fails to comply with subregulation 2 and 3. 2 and 3 is you can't meet. commits an offence and is on conviction liable to a fine or imprisonment for a period not exceeding 6 months or to both such fine and imprisonment. Sub 20 says a person who attends, not just the convener, the person who attends a faith-based, religious, social, political, or cultural gathering and who knows or ought reasonably to have known or suspected that it's prohibited, commits an offence and is on conviction liable to a fine or imprisonment for a period not exceeding 6 months or to both such fine or imprisonment. Now, 18, which precedes it, says an enforcement officer must, where a gathering in contravention of the regulations takes place, order the person of the gathering to disperse immediately, and if the person refuses to disperse, take appropriate action which may be subject to the Criminal Procedure Act, include the arrest and detention of any person at the gathering. That provision is the same as under the old regulations. The new ones are 19 and 20. And that is the same, my Lord, even under the June regulations. So when I submit to your Lordship that she's up the ante, this is not rhetoric. It is very, very, very serious. If you convene a religious gathering, it's a crime. So what she's just done, where people now have a conviction of their religion, she's just criminalized you doing so. That's what she's done. And there's no second chances. It is an immediate
when you
fine.
say that this is the point that Mr. Mukhagabe objected to, we're not going to be looking at the July regulations.
No, my Lord.
Except to say that it's not moot.
Precisely. And that's why I'm making the argument in that context. But what I'm submitting to your Lordship.
Does the July 2021 regulations have also been superseded?
Yes, they have. Because we keep moving through different regulations, and I'll address that on the topic of mootness.
And this particular two sub-regulations no longer.
Well, they're alive if we go back to that level, unless there's an adjusted level, and it depends on what the minister does with them.
So they don't prevail at the moment.
No, well, not at the moment, my Lord, because we're not at that level. We're no longer under this level because we were set free after July, and I'll show you, Lordship, that in a moment. If you've got a difficulty, my Lord, and in fact, I'm getting a message from my junior that they may still be alive if you traverse the 750 number inside at the moment and 2,000 outside limit. But I'll get them to check that. But all I'm submitting to your Lordship in this context.
Level 3, just at level 4.
Exactly, my Lord. This is at this adjusted level, and I'm going to submit in the context of mootness that, as is said in our learned friends' heads, the heads for the minister, at 054-90. It starts at paragraph 4, in fact, at page 89. She says that it's complex, and that's why they've introduced the risk-adjusted strategy. I don't want to take myself out of my stride, but it's obviously a point that's relevant for your Lordship. But it goes to the mootness argument. I was going to raise it in a different context. But your Lordship will see at paragraph 5, they say the philosophy underlying the RAS, the risk-adjusted strategy, is that by employing different alert levels, government is best able to ensure the appropriate restrictions are in place to limit the transmission of the virus, while at the same, which I presume they mean time, minimizing any incursion into people's lives as far as possible. For this reason, government has not merely imposed the harshest alert level, level 5, for the duration of the national state of disaster, despite the fact that this would undoubtedly result in low transmission rates. Instead, mindful of the social, my Lord, she doesn't say economic, social and economic consequences of harsh restrictions, it is engaged in a careful and orchestrated balancing act by frequently adjusting alert levels to introduce the appropriate restrictions necessary to protect the public and slow the transmission of the virus while trying to minimize undue restrictions. That's the balance which I said to your Lordship with reference to our answering affidavit. That's what my learned friends say in their heads on behalf of the minister. It's a balance. So to argue this is moot, once we could go back into that, and that's what his Lordship, Mr. Justice Plaskett, said. He said, this is still alive. We can go back up and down. The only one he said wasn't alive was the one about clothing, because they abandoned that one and never went back there again. And so he said, I don't have to address that. But he addressed the hot chicken dinners and the exercise, as I'll show you, Lordship, in due course. But what I'm submitting to your lordship in the context of practicing your religion is that this right, constitutional right of freedom of religion, and what the minister is doing here, as we said in our founding affidavit, doesn't just implicate sections 15 and 31. It implicates the right not to be arrested, and it implicates fundamentally dignity, my lord. I'm not going to repeat the arguments of dignity because my learned friend Mr. Botha did that so well. But what you can see is that there's no greater invasion of your dignity than in arresting you for practicing your religion. Especially, my lord, and your lordship would know this, your lordship would take common sense of judicial notice of. Religious people, by definition, means people who obey laws, because that's what religion means. We all have different laws depending on our religion, but it's inherent in people who practice religion that they want to obey the law. If there were doubt about this, we address it in our papers, my lord. But Romans chapter 13 for Christian people is fundamental. Romans chapter 13 instructs Christian people to be subject to the governing authorities. It literally reads, let every person be subject to the governing authorities. For there is no authority except from God, and those that exist have been instituted by God. Therefore, whoever resists the authorities resists what God has appointed, and those who resist will incur judgment. For rulers are not a terror to good conduct, but to bad. Would you have not fear of the one who is authority? Then do what is good, and you'll receive his approval. My lord, the point is simple. This person now has Hobson's choice. Now, it may seem that in these holy scriptures there's a contradiction, but it's an easy contradiction to deal with. Where the Lord commands you to do X, you do X. If government commands you otherwise, you suffer the punishment. The moving of your goods, practicing your faith, that's what you do. But otherwise, every authority under God's authority, in other words, obeying God's laws, must be obeyed. So what you do is you put a religious person in Hobson's choice. They are instructed to obey the laws. They're not people who willy-nilly just go and do things. We know that by definition. Lord, we uploaded another document to case lines. And this is something I respectfully submit when I deal with judicial notice, your lordship can take judicial notice of. It's a letter from the president to the whole country. And what the president says is he tells in this lengthy letter, he gives the example of Martin Luther, which is he commends the religious community and says you're acting just like Martin Luther did, which was on the one hand to keep people safe, to fumigate houses, take medicines, protect people, but at the same time, you're supporting people with your faith. That's the example he gives. It's a passage written 500 years ago, my lord, that he quotes. He says that in many ways, the views expressed by Martin Luther 5 centuries ago echo the position of religious leaders in South Africa in the midst of the current pandemic. He says faith-based organization being vital to our national response to the disease, not only providing spiritual comfort and guidance, but also by caring for those most vulnerable to the effects of the pandemic, including through the provision of food, shelter, and other social services. Religion plays an important role in the lives of millions, my lord. It's not dealing with some minority here of South Africans. And congregational worship forms a vital part of their religious practice. The government knows this. The president knows this. And he explains that. And he commends them for being constructive and for them being assistive and for them helping people. And that those are the people that religious people are. In fact, what they do is they encourage people, as he says in his letter, to obey the law. Now, this gets to, and I'm traversing a number of different grounds, but it's convenient to address it now, my lord. The second set of regulations, those that were attached, which we said were missing on the 14th of July, same date of our supplementary, of course, we didn't expect that to happen, and they then filed those regulations. We expected the minister to include them, the minister doesn't. My learned friend says, oh no, those are not relevant because that doesn't deal with the pandemic. He says in his argument that it deals with a different issue because he says that deals with the riots. Well, here's the actual farce about that, my lord. Those regulations, and I'm dealing with this in the context of religious people being law-abiding citizens. That's what I'm submitting to your lordship, is that they are inherently law-abiding. If that were not so, why would the government ask those same religious people to convene meetings, of community meetings, in the middle of the riots? It's to deal with the emergency situation, to bring calm. to allow people to say, well, you can't do this anymore. Lord will find the Government Gazette as passed at 011-472. That's the first one. It's DE2-3, 011-472. My Lord, I've directed your Lordship to the page. Your Lordship will see there that the first regulation, there's 2 regulations passed on the same day. It says gatherings at community engagements hosted by members of parliament, members of provincial legislature, councillors, leaders of political parties, religious leaders and traditional leaders to deal with emergency matters are permitted. So in the middle of these regulations, which I just showed you, Lordship, where you can get arrested for a religious gathering, the religious minister is now to convene, because we have riots 3 days later after they promulgated the 11th July. Now the religious leader, who's obviously a leader, obviously conscientious, otherwise why would they put him to convene this meeting? Obviously law-abiding, says you can have such a meeting. Now that wording, obviously the minister thought that was too vague, because the minister shortly, probably a couple of hours, whatever it was later, but the same day, passes another regulation. And your Lordship will find that a few pages on at 011-474. I've directed your Lordship to that page. Now you'll see that the wording changes. Now this is where my learned friend Mr. Mogabe's argument clearly was not correct, my Lord, because he said this is to deal with the violence, and he only read your Lordship the first regulation. The first regulation says the violence. Now let's look at the confusion that comes with the second regulation. 4A. She deletes the previous one that she just passed the same day. She says gatherings at community engagements. So now you can gather. The same people that religious leaders would normally gather in their churches or in their mosques or in their synagogues can gather. They permit it. If you are religious leaders to deal with emergency matters, now they say emergency matters that impact on, what do they impact on? Management, treatment, and prevention of COVID-19 pandemic are permitted, subject to a limitation of 50 persons or less, and if the relevant space is too small to hold the prescribed number of persons observing a distance of at least 1.5 meters from each other, then not more than 50% of capacity of the space may be used, subject to strict adherence to all health protocols and social distancing measures. So now, funnily, now you can meet to discuss COVID in a church with a community gathering, with a religious leader leading this up to discuss that. But you couldn't do it 3 days earlier, and you can't actually get to church on a Sunday unless you're going to preach about the COVID-19 pandemic. Now, Lord, with respect, what would a religious leader say to the people? The context is the riots, but look at the way they've changed the regulation. What is he going to tell people? Why does the government rely on him? Because religious people are inherently law-abiding. So what does he want them to do? He wants to say, would you tell everybody to obey the law? Now, why would a religious person do that? Because I've just read your Lordship Romans 13, and I've no doubt my learned friend Mr. Botha would be able to quote your Lordship passages from the Quran which would say the same thing. You must obey the law. So now we've got religious people that are called upon by the government in the middle of the pandemic. We have in the supplementary affidavit, Lord, of the minister, which she presents, you have a graph. That graph, my Lord, we'll find at page 011445. I'm directing your Lordship to the page.
Yes.
This gives your Lordship the various waves that the parties went through, or that the country's gone through. Now, they cut that off in the second wave, 10 November 2021. But your Lordship will know that on the 14th of July, this graph comes from Google, my Lord. If you just Google this graph, you'll get the same one. What we put up in our supplementary affidavit is the updated graph. That's the one that they didn't want in. Your Lordship will see if you simply Google COVID stats SA, you will get the exact same graph. But what it'll show your Lordship is that when this happened, it was at the height of the pandemic in July of this year. And your Lordship will see that this graph does cover this year, in fact, on my mistake, my Lord, it does cover this year. But your Lordship will see the third wave is in this graph. Your Lordship will see that the bottom of the wave is 20 May, 15 August is the bottom. If your lordship goes to Google and looks at where we were on the 14th of July, we were at the height of the pandemic, where we had daily cases in excess of 17,489. We had just passed the peak of infection. Daily cases. Today we're at 600 or something. 17,000 was the 7-day average, 17,781. My lord, in the middle of that, who do they call upon to help them because we have riots and looting on the streets? In Mr. Mokgakabe's own words, the religious leaders. Now, for a religious leader to face being arrested if he has a gathering on a Sunday to preach a message, as opposed to gathering the same people to tell them that Romans 13 says he must obey the law, is clearly irrational. But it is a clear invasion of his dignity. I'm dealing with this in the context of Section 10 of the Constitution. It is a religious leader being arrested, my lord, is undignified. People may put being a martyr on a pedestal, but it's hardly something you want to do. As a religious leader, being arrested for disobeying the law. Lord, that is the context.
Tutu did it so many times. In my
I beg your lordship's pardon?
Bishop Desmond Tutu and others did it so being arrested publicly all the time in my time.
Indeed, sir, my lord, because they stood up for what they believed in. And they stood up for what they believed in. And his lordship, Mr. Desmond Tutu, Bishop Desmond Tutu, and Archbishop Emeritus, I think that's his title, is such a good example of what the religious Hobson's choice is. Because you act according to your conscience, and you do what is right according to your conscience, but more importantly, your conscience is directed by your belief system. And that what then happens is you end up being arrested by this government and because of these regulations. Finally, my lord, just on the Constitution, Section 39 deals with the interpretation. And I'm going to just draw 2 points, 39(1)(b). Well, 1A, of course, says must promote the values that underlie an open democratic society based on human dignity, equality, and freedom. The fundamentals, human dignity is right there. Sub B must consider international law, and sub C may consider foreign law.
My lord, may I just intervene, my lord?
Sure.
I have been raising, my hand, my lord, for almost 15, 20 minutes.
I'm so sorry. I've been looking at the document. Thank you.
Yes.
My apologies. I've been looking at the documents they're referring me to.
In fact, my lord,
I'm not watching the screen of
yes,
the proceedings.
I have the purpose, my lord, was just to object to what Mr. Botha has been submitted to the court relating to regulations which are not the subject matter of these proceedings. My lord, as your lordship has argued,
and I'm taking note of that.
And it's not only for purposes of mootness, my lord, but it's for purposes of other aspect of the case, my lord. So, and interpreting these regulations, my lord, it is not proper for them to do so, my lord. The regulation not before the court. If it's for, it is not for mootness, my lord, because the way it has been argued, my lord, before the court.
Yeah, okay, for the sake
making
of
a distinction between, yes.
For the sake of avoiding getting into an unnecessary skirmish that will detract us, I'm going to now ask Mr. Botha to move on. I think the point has been, you can just move on.
I was going to move on, my lord, and I've dealt with the issue, and we will stick to mootness. It doesn't matter, my lord. If I may refer your lordship to our heads of argument.
How much longer do you have, Mr.? How much longer will you be?
Oh, my lord, I will be at least another 45 minutes, I would suggest.
That's 2 hours you're taking.
Yeah, I did warn your lordship up front because of the nature of the questions your lordship posed. And the issue, your lordship, my lord, with respect, what I've dealt with, nothing I've dealt with is irrelevant, and I haven't repeated anything said, but I'm addressing your lordship's question, where your lordship says that religious people can practice their religion in their own bedroom and they're not allowed to gather because the minister says so. With respect, I have to address those arguments, my lord. I can't be curtailed from addressing those arguments.
Okay, if you want to take that long. Mr. Mokgakabe? We're going to obviously, it's going to obviously take a bit longer.
Yes.
I'm going to ask you to be a bit more succinct and less over-explanatory.
As your lordship pleases.
So make your points, but without they come across. We don't, you know,
As your lordship pleases.
excessive explanation for them. So I'm trying to get you to, but we're going to have to adjourn, of course, and come back. And maybe that'll give you an opportunity to look at the points you want to make and see how you can. It's more difficult to reconstruct your argument while arguing. It's easier to reconstruct it while you have a few bit of moments on your own of reflection.
As your lordship pleases. I will keep it more brief, my lord.
Okay, so can we then adjourn now, and we'll come back in half an hour? What is the time now?
It's 1 o'clock, my lord, or 2 minutes past 1.
1:30 we come back.
Thank you, my lord.
And Mr. Mokgakabe will start from there, and then we might adjourn again at 3 for a short while to see how long Mr. Mokgakabe is. And then see, we'll carry on till the end of the day for Mr. Mokgakabe. And if he needs to continue, he'll continue tomorrow. Mr. Mokgakabe?
My lord, I'm indebted to your lordship, my lord. I will try to be as expeditious as possible, my lord. I mean, in dealing with all of these issues, my lord.
Yes, they've raised a lot, and you got a lot to answer to. So
I have a lot to answer, my lord.
you're not going to be restricted. That I can assure you.
Yes.
Okay. So we'll.
But I'm not gonna raise issues which are not before the court, my lord. Definitely,
Yes.
my lord.
Yes, and you just point out which.
I'll just point out.
And say we must ignore those issues.
Thank you, my lord.
Thank you, my lord.
So we'll start at 1:30.
Thank you, my lord.
Court is adjourned.
I can now jump to, having set the stage, I can jump to our heads, which I would ask your lordship to turn to page, well, your lordship doesn't necessarily need to go there, but, and I'm mindful of time, my lord, but 054 -9 in the heads of argument. So it's 054-9 or -9 from paragraphs 11 by heads of argument, my lord, onwards to paragraph 19. What we do there is we describe what the nature of this constitutional right is, my lord. What's important is the right entails, as I've expressed to your lordship, the right as per S versus Lawrence to entertain such religious beliefs as a person chooses, the right to declare those religious beliefs openly without fear of hindrance or reprisal, and the right to manifest religious belief by worship and practice, by teaching and dissemination. We deal, my lord, with the Swiss Constitutional Chamber, which reference the International Covenant on Civil and Political Rights, that deals with the religious freedom, both the inner freedom to believe and the outer one to express those convictions and to practice them, very importantly, my lord, and includes the right of everyone to behave in principle according to the teachings of their faith and to act in accordance with their convictions. So, my lord, the fundamental practice, the point we make at paragraph 13 of most religions is meeting and gathering, and as I've pointed out to your lordship, section 31 sub 1 encapsulates that right. So, as is the case, my lord, at paragraph 14, and this is important, this relates to the question your lordship posed to my own friend, Miss Martin, as to how far this right goes. The court has expressed itself and explains this very clearly in the Christian education case, my lord. Your lordship will see that from paragraph 14 of our heads. It's not to say that that religious rights can't be limited. Of course they can be limited, like all rights, in appropriate circumstances. But of course, at that test, it must pass constitutional muster, my lord. And his lordship, Mr. Justice Sachs, writing for the unanimous Constitutional Court, describes that test in the context of section 36, and we've quoted it at 054-11 of our heads. So to sum up, the learned judge says, limitations on constitutional rights can pass constitutional muster only if the court concludes that considering the nature and importance of the right and the extent to which it is limited, such limitation is justified in relation to the purpose, importance, and effect of the provision which results in this limitation, taking into account the availability of less restrictive means to achieve this purpose. We've highlighted that, my lord, by underlining it. That's actually what this case is about. The question is, what are the means that can be used, and are there less restrictive means available? Though there might be special problems attendant on undertaking the limitations analysis in respect of religious practices, the learned judge is recognizing what I've just submitted to your lordship, the entanglement, the nature of these rights, etc. The standard to be applied is the nuanced and contextual one required by section 36 and not the rigid one of strict scrutiny. So that's why we submit to your lordship, that's what this case is about. Here we're obviously dealing with a balancing exercise we submit, as we've pointed out in the heads. It's the balancing exercise contemplated in section 36, and his lordship, Mr. Justice Sachs, again, after considering the context of religious freedom, says, accordingly, believers cannot claim an automatic right to be exempted by their beliefs from the laws of the land. At the same time, the state should, wherever reasonably possible, that's the test, wherever reasonably possible, seek to avoid putting believers to extremely painful and intensely burdensome choices of either being true to their faith or else respectful of the law. So what we respectfully submit, my lord, at paragraph 16 is reasonably possible, despite the pandemic, is not to unreasonably limit people from practicing their religion safely, in the same way that people during the same time period were not restricted from carrying on their other activities, especially the permitted activities. Those are the activities we've defined above, my lord, going to gym, going to a restaurant, etc. And they're all categorized. You'll see that the minister has consistently categorized them together in the various regulations over time. When she opens the one, she opens the other. It's the inconsistency that arrives, for instance, in these regulations, where in December initially everybody was locked down. When the January regulations came, they opened up restaurants and they opened up gyms, but they didn't open up for Christian services, and so, or for any other religious services and faith-based gatherings. So, my Lord, it's at that point where we respectfully submit, it's that complete failure by the response to take into account the availability of less restrictive means to achieve the purpose of the DMA regulations in order to deal with the COVID-19 pandemic that gives rise to the present challenge as a result of the complete ban. This application was accordingly launched in that background. And then we quote for your lordship the Dwayne Esau, I think it's how they say it, Esau case, and where the learned judge says, even in times of national crisis, as this undoubtedly is, the executive has no free hand to act as it pleases. All the measures it adopts, it must adopt measures to meet the exigencies that the nation faces, must be rooted in law and comply with the Constitution and the rule of law, my lord. That's the point he makes. That's not different to the international cases. And your lordship will see the statement of his lordship, Mr. Justice Gorsuch, in the Roman Catholic Diocese of Brooklyn case versus Cuomo. Even if the Constitution has taken a holiday during the pandemic, it cannot become a sabbatical. And that's what we have. Now, that case, we're going to commend it to your lordship. It's part of our bundle. Lordship will find that in that case, what they do is they set aside, precisely because of this distinction between economic activity and the activities of religious gatherings. And they say it's not rational, it's not justifiable to have that distinction. And we respectfully submit that the position is no different in our law.
Can that be right? I mean, the mere fact that you're trying to provide someone with the opportunity to continue with acquiring the means of living is slightly, is in their view, not different at all from someone that's meeting to pray.
Lord, that's what the Supreme Court...
I know there's the spiritual element which is necessary for people to survive, but does the fact that someone's earning a living not make it slightly different?
My Lord, I'm going to address the earning of the living in the next paragraph. I'm just commending the judgment to your lordship, but that is what the majority of the Supreme Court in the US found. And we respectfully submit that that is so. And again, the economic test is not necessarily the one that the minister is putting forward, but I'm going to deal with that separately in a moment. Just under this heading, I'm going to just commend to your lordship just also the content of the religious right. I'm not going to take your lordship there in detail, but your lordship will find the Pillay case. It's been referred to by several others. And what the Pillay case, it's at 055-789 of our authorities bundle. 055-789, and what it does is it sets out the content of this right and how, even though the school said in that case, why can't she just take out her nose ring during the day? And the court found that that's not a reasonable accommodation in those circumstances, and the court found that she needed to be accommodated. So, my Lord, that is the balancing of those particular rights and the importance with which our courts have held them to be. So, my Lord, ultimately, I would also commend to your lordship 05439, which is our heads of argument, just for purposes of expedience. 05439, paragraph 74, your lordship will see there that we deal in even more detail with the nature of the fundamental rights. And we again deal with international jurisprudence in regard to the contents of those rights. And paragraph 78 onwards, your lordship will see. So that's 05439, paragraph 78. And we deal with that in more detail there, and I'm not going to detain your lordship any further. I've summarized the position in our respectful submission. What that brings me to, my lord, and I'm going to come to the economic point in a moment, but the other point your lordship raised is that the ban is temporary. Lord, what we respectfully submit in the light of his lordship Mr. Justice Sachs' judgment in the Christian education matter, that is partly bound up with a reasonable test, reasonableness. Could this be achieved in another way? That's where we are. And I'm going to take your lordship in due course to the SR judgment, where you have a short circuit breaker, I think as they called it internationally, where you put a stop and everybody has to stay at home. That's perfectly understandable. It's not ideal, and I'm sure many religious people wouldn't rely on it, wouldn't find that a happy circumstance. But where you're being treated the same as everybody else, that's one thing. It's when you have a circuit breaker and then you open up to other activities, but not to religious activities. And that's where the duration comes in. But bearing in mind also that even a temporary ban is still an infringement of the right. It's still an infringement of what is a fundamental right. And to those who practice their religion goes to the heart of it. And bearing in mind, my lord, and we make this point in our papers, and it's made even more in the SANCF papers, which we incorporated those submissions by reference. Many people in this population don't have Wi-Fi, don't have internet. It's all well and good telling people watch on TV or watch online. That's not possible. So for many people, when you say, even if it's a temporary ban, you are absolutely excluding them from practicing their religion and gathering together. And that goes to the indignity of it all, my lord. And it is indeed not only an affront to a religious person, as Mr. Botha submitted, to watch somebody go and gamble next door when you can't go to church, but it gravely impairs the sense of justice, equality, and dignity of that person. Lord, do not address the issue of the economy. Our first submission in this regard, my lord, is with respect, your lordship is asking the wrong question. Your lordship says, isn't this a matter of balancing the economy and dealing with religion rights? And your lordship is with respect elevating section 22 of the Constitution for the right to make a living above religious freedom rights. They're both constitutionally protected. Let's assume they were of equal weight, which they aren't when you discriminate against somebody on the grounds of religion under section 9. But even if they were, why treat me differently? If they're both fundamental rights, you'd need to give a very sound reason why you don't treat people the same. And I'll deal with the rationality in due course, but just dealing with it at a fundamental principle level. If you were to compare the two in the scheme of the fundamental rights provisions, we respectfully submit that section 15(1) in fact trumps section 22. But even if it didn't, what justification can there be to give effect to one right whilst excluding the other? But the correct approach, my lord, with respect, is the one that his lordship Mr. Justice Sachs said. There is a right to practice your religion. That right is being infringed. Not only is it that right that is being infringed, but it is your right to equality and dignity and to be equally treated before the law that is being infringed. Once that is infringed, the question is whether that right may be limited under section 36. Now, SR, my lord, your lordship will find in our authorities bundle, and I'm going to refer to it quite extensively, we've inserted both the ARCO judgment and the Supreme Court of Appeal judgment, but the Supreme Court of Appeal you'll find at 055-443. So from paragraph 106 of that judgment onwards, your lordship will find the test in dealing specifically with these regulations. Now, amongst others in this context, the learned judge is referring to procedural rationality. My learned friend, Ms. Engelbrecht, has already dealt with the issue of whether this is administrative law or whether it is legality, a legality challenge. It doesn't matter because his lordship analyzes the case on both. But the finding is, in this case, that it is PADJA, my lord. And ultimately, for that reason, we submit that your lordship's bound by that decision, whatever our learned friends may submit. But from paragraph 106 of the judgment, his lordship begins to explain section 36 of the Constitution, and we commend it to your lordship. And from 108, he explains that the determination of the constitutionality of the impugned regulations involves a two-stage process. First, the appellants are required to establish that the regulations infringe one or more of the fundamental rights. My lord, that's established. It's clear. Secondly, if they succeed in establishing this, the burden shifts to the respondents to justify the infringement or infringements in terms of 36(1) of the Constitution. Now, of course, here there's that double threshold, which I've referred your lordship to, Mr. Botha has. But if they fail to do so, the offending regulations must be declared to be invalid to the extent of their inconsistency with the Constitution. If it is just and equitable to do so, a court may limit the retrospective effect of the declaration of an invalidity or suspend it for a period to allow the competent authority to correct the defect. Lord, I've noted in my learned friends' heads, or the, shall we say, the ministers' heads, that there's a suggestion that there should be some kind of just and equitable remedy here. That argument can't live with the mootness argument. Your lordship will make a declaration of invalidity. You'll say that they were irregular. They have every opportunity under the next round of regulations to pass valid regulations. There's no need for a retrospective or a limiting of the retrospectivity because on their version, they're no longer alive. But at the end of the day,
in your understanding, the order, if you win, would simply be a declarative.
Exactly.
The regulations, the two impugned regulations, were unconstitutional.
Indeed, so, my lord. That is our respectful submission. A learned judge explains that if the respondents justify their infringement or infringements of the fundamental rights, then the regulations are valid. Their impact on the fundamental rights have been sanctioned by the Constitution. So that's the test, my lord. So to start with, worrying about economics or otherwise, my lord, is not the appropriate test. The test is to measure it against, has there been an infringement? And then it's up to the minister to go and explain to your lordship why that infringement is justifiable under Section 36. Now, the real question your lordship will have to deal with is, has the minister discharged that onus? We submit not. I'll demonstrate to your lordship in due course why not. But the question that is asked before that is, how does she discharge this onus? And his lordship, Mr. Justice Plaskett, tells us this too in this judgment at paragraph 146. Where he is now dealing, your lordship will note that he deals with two aspects. He deals with a number of aspects. He deals with procedural regularity, and I'll deal with that, touch on that when I deal with consultation. But from 144, he deals with the exercise regulation. Your lordship will recall that people were limited to exercising at certain times and in certain places and certain types of exercise. And the learned judge says at paragraph 146, no attempt has been made to justify why only 3 forms of exercise were permitted. It's difficult to imagine a rational reason. Why, for instance, should a person not be permitted to exercise by canoeing or kayaking on a river or a dam? Why should a person not be permitted to exercise by swimming in a dam or river? Similarly, no reasons have been given to justify why people were restricted to taking exercise within 5 kilometers of their home. Why should a person not be permitted to travel 6 kilometers from home to hike in the veld or up a mountain? In the absence of explanations, this is the important part, for these limitations, I find there is no rational explanation to justify them. The result is that no rational connection has been established between restrictions and their ostensible purpose. They are also disproportional because their necessity has not been demonstrated, nor is it obvious or explained. Now, my lord, the learned judge refers in footnotes 137 and 138 to other authorities where that point is elaborated upon, but he has succinctly stated the point. All that you've got to do is that the minister has to do is they have to give a justification. They have to explain why the one way or the other. And there needs to be some explanation. Now, the minister cannot discharge an onus where the minister hasn't given your lordship reasons. The only reasons with respect, my lord, as the minister herself says, when we ask for reasons, is in the answering affidavit to Part A. She says, those are your reasons. And she limits herself to those reasons. Because when we ask her for reasons after Part A is postponed, as we're entitled to under Rule 53, says you can't have any. And I'm not giving you any. So whether it's under Padua or illegality, and my learned friend will no doubt submit, because this is some kind of polycentric, they allege, we'll address that, polycentric argument that they don't have to give reasons, that's wrong. Because we've submitted in our heads and we've given your lordship case law that says even in the case of legality, You have to give a reason. Otherwise, how does the court judge whether you were acting rationally or not? Because even under legality, there's a rationality test. But, my lord, as I've already submitted, your lordship is bound by PAJA. Now, therefore, in this test, which I've just described to your lordship, the debate about economics doesn't come in. It's not to say because she's let somebody else out, now there's a, there's some kind of weighing up of that exercise. No. What the relevance is of these other activities being allowed is that they demonstrate, as I've already submitted to your lordship, that there's a more reasonable way of achieving the purpose. How do you go to a restaurant and take off a mask, and you can gather with as many friends as you like, and people sit at a restaurant table right next to each other? You can take off your mask, COVID suddenly disappears while you're eating. If you pull out a Bible, or it suddenly becomes a meeting where you're dealing with religious matters, and I take your lordship's point from earlier, but with respect, on that basis, on what the minister seems to say, you have coffee or a meal. Now you can't do that either. But what is the rationality of doing that? Because what should have to say, these people who abide by laws by nature are less likely to abide by the laws than somebody who goes to a restaurant and has alcohol. Now, this point, my lord, is exactly the point that is made in the foreign judgments, to say, on what rational basis can you contend that somebody in a restaurant is less likely to spread the disease? You can't. There's no basis for that basis, and that's what my learned friend, Mr. Botha, submitted to your lordship with reference to virologist and evidence. But the minister doesn't do that. The minister doesn't put up the evidence. She bears the onus. So the debate around economics is a red herring, with respect, my lord. It's not about that issue. I can let some people out. It's about, have you infringed the religious right to freedom? And can I have achieved that in a better way? And if you've let other people out who are just as likely to spread the disease, then you cannot give a justification for your restriction. It cannot be justifiable or reasonable in the balancing exercise of those respective rights. And it doesn't mean that just because you allow a religious gathering, it's not one or the other. You don't say, well, I must choose religion over restaurant. No, my lord, they can both operate at the limit of 50. Because otherwise the minister has to say to your lordship, and she doesn't say this, that there is a very high risk of spreading the disease. And I'm sorry, I'm somebody's not muted, my lord. Mohammed Mullah, my lord. You could just put off their microphone, my lord, with respect. Thank you. My lord, so the nub of the question is, it's not a choice between these alternatives. The question is, if the minister says that it's safe enough for people to eat at a restaurant, to sit in a taxi, safe enough for purposes of spreading the disease, safe enough, why is it not safe enough for a church? And that's the question that the minister, with respect, never ever answers in the papers. You're left without any proper reasons, and I'll take your lordship momentarily to the reasons that she does give. And I'll demonstrate to your lordship that each of those reasons are only anecdotal, they're not scientifically based, and they're unsound because we're not comparing like for like. But what's more important, my lord, is an alternative. And perhaps here I can just marry the arguments of my learned friend, Miss Martin. Your lordship has sought to suggest, it seems, to my learned friend in imposing the question that churches have nothing to do with economics. Lord, with respect, that can never be so. Why? As I referred your lordship to the letter from the president, what do churches do? They are the inventors of redistribution of wealth, Lord. It's not a communist or socialist idea. It happens in the book of Acts chapter 2 and Acts chapter 4. It's what they do. They provided for each other amongst themselves. It says they had all goods amongst them equally. That's what the scripture tells us. In James chapter 1, verse 27, it says, true undefiled religion before God is taking care of widows and orphans. You are instructed, not, as James says in chapter 2, you can't just tell the widow or orphan, be blessed, warmed, and healed, and not give them anything. They are fundamental to the economy, as social grants are fundamental to the economy. The president recognizes that in his letter. It's not disputed that that is so. So what we have is a situation where churches are vital to the economy. That's at the one level. But there's another reason. My Lord, churches must also be distinguished between church workers. At the first level, there can be no debate that churches run activities. They have bookshops, they have coffee shops, they run businesses, they collect tithes and offerings, as SANCF explains to your lordship. In those poorer communities, we don't have things like EFTs. They come to church and they give their money. What are these funds used for? They're used, firstly, to redistribute to those in need. But secondly, and just as importantly, they feed the church workers. Now, perhaps some people get overly pious and suggest, oh no, church workers should never be getting any money from anybody's tithe or offering. But that's naive, my lord, and is not scripturally sound. Nobody's suggesting that the pastor is supposed to be rich and fly around in jets, as some of the notorious people overseas that we've seen. But what is clear from the scriptures is, and this goes back whether you're Jewish or whether you're Christian to the Old Testament, when the Lord called priests in the book of Exodus, and he deals with it in Leviticus, Numbers, and Deuteronomy. The Old Testament for Jews and for Christians is the same. What he does is he calls priests and he says, I'm not going to give you an inheritance in the form of land. I'm your inheritance. What people will do is they'll bring you a tithe and you'll live off the tithe. They lived off the offerings in the temple. That doesn't change in the New Testament. In 1 Timothy 5:18, it tells us, don't muzzle an ox when it treads out the grain. The laborer deserves his wages. He's explaining that in the context of church workers being entitled to earn money from the tithe and the offering. In 1 Corinthians 9:9, it says, for it's written in the law of Moses, you shall not muzzle an ox when it treads out the grain. Is it for oxen God is concerned? Does he not certainly speak for our sake? It was written for our sake, because the plowman should plow in hope, and the thresher thresh in hope of sharing in the crop. If we've sown spiritual things among you, is it too much if we reap material things from you? If others share this rightful claim on you, do not we even more? Nevertheless, we've not made use of this right, but we endure anything rather than put an obstacle in the way of the gospel of Christ, he explains. What he is showing, my Lord, is that that's how ministers of religion earn a living, in inverted commas. What the SANCF application demonstrates, your lordship, is they're not entitled to the stipends and they're not getting any support. So because of the nature and the informal nature of it, doesn't make them any less dependent on the economics. So, my lord, there's a distinction. At the one level, there is the right to the individual and the congregant to congregate together, which is secured under section 15.1 of the Constitution and under section 31.1 of the Constitution, clearly and unequivocally. That is a right that is unrelated to pecuniosity. It's got nothing to do with money per se, except, as the SANCF explains, that is where people get fed. They come to church on a Sunday and they receive their food. That's how these distributions happen. It happens on those gatherings. Once it's a faith-based gathering or a religious gathering, one can't separate that from a feeding scheme or otherwise. It is the same thing. They're one and the same. The people gather together and the purpose is the same. That's at the one level. But at the other level, not only do churches add to the economy by providing this food and assisting others, but more importantly, they also have to minister to those religious leaders who just don't have any money. So if your lordship puts to us that section 22, what about the poor restaurateur? There's a distinction again between the restaurateur and his clients or customers. Those coming to eat a meal have no right to have a meal at a restaurant.
Ladies and gentlemen,
with respect,
please
you
note
can
that
search the Constitution far and wide.
We have about
You'll not
2
find one
minutes or so.
provision that says, I need to go to a restaurant to eat a meal. So in that respect, they are significantly in a different position to those who are practicing their religion, who have a right to attend church. But if your lordship says, open up the restaurant so that the restaurateur can make a living. A fortiori, the same thing for the minister. Not only is he performing a vital social function as conceded by the president, counseling people, advancing their interests, making sure that they are healthy. You can go see a doctor during the pandemic. You should be able to see your priest. Many people, that's more important to them.
Would that be prohibited in terms of the regulation?
It is currently that's why the essential service workers argument, my lord, which I'll get to momentarily. So you can see your doctor at any time, or your doctor can come to you because he's an essential service worker. Well, as soon as we get into situations where we're in lockdown level 5, or the priest can't move, or when there's a curfew, unless your essential service worker is entitled to move, he can't move. Even the psychologist, you can go see a psychologist, and many people would consider their priest. As we know, we've got a confession, a confessional. A priest is like a psychologist. You can go see your psychologist. There's an exemption for that because they're an essential service worker, but not for purposes of seeing your priest or your minister. When somebody is dying, my lord, we all know last rites are administered. Death doesn't happen between curfew hours. Death happens whenever. And what happens is now the priest can't go and administer the last rites because he's not an essential service worker. If he goes, he will be arrested. So, my lord, that's the distinction between these different positions, is that whereas a restaurateur may have a right under Section 22, the poor Christian worker not only has that right under Section 22 to make a living, but he also is conflicted because he can't minister to his congregation, which normally happens in a congregated setting. Once that is the factual reference, with respect, even if your lordship found I was wrong in my submissions in regard to the fundamental rights test, which I respectfully submit cannot be so given the judgment of his lordship, Mr. Justice Sachs, and what ESSAW itself says as to how you measure it, they also have economic interests. And that's what the SANCF explains in such detail. So, my lord, a blanket ban, which is the same as going back to level 5, is very different where everybody is under the blanket ban. That's what his lordship, Mr. Justice Plaskett, describes. And in that situation, initially what happened is everybody was banned, and then we moved to level 4. That's what that case was about. But what then happens, and he says it's understandable in those circumstances that everybody is shut out. But when you start opening up, and that's why he deals with the issue of exercise and hot chicken dinners, my lord, the hot meals, he criticizes that. He says, what's the rationality of standing in a queue for a hot meal versus standing in a queue to pay at the checkout counter? Well, with respect, the same reasoning applies. What's the difference with standing next to each other and we're not allowed to pray and we're not allowed to worship? Even though restrictions are put in place, social distancing, masks, they are detailed, and we put them in our papers, my lord. After May, there was a detail circumscribed. Only one person could sing. People couldn't all sing. You only were allowed to have one performer, one person playing a musical instrument. We don't attack those regulations. That's not a problem. What they demonstrate is that one can achieve the same purpose reasonably, as his lordship, Mr. Justice Sachs says, is the test. What the demonstration is, how do you compare that to going to a restaurant? It's no worse. And if you say that it is worse, then put the restrictions in place, which is what the minister did. And when she did do that, she opened up prior to restaurants. Once that is so, how can it ever be suggested that the purpose of preventing the pandemic from spreading cannot be reached in a less restrictive manner? So, my lord, that's where the equality comes in. And that's where the equality arguments then fit in. Lord, if I can then just deal with the rationality aspect. As far as rationality is concerned, my lord, I've already given your lordship several examples. Your lordship suggested, can't recall whether it was to Miss Martin or I think it was to my learned friend, Mr. Botha. Your lordship suggested, but these things are never going to be perfect. Lord, nobody's asking for perfection. The test is set out in the SR judgment. What they have to be is rational. My lord, if they are irrational, even if some mistakes are going to happen, those ones will be set aside. That's what his lordship, Mr. Justice Plaskett, does. and the whole Supreme Court of Appeal bench with him in a unanimous judgment. Petsy, Deputy President Zondi van der Merwe and Mabindla Bokwana. All of them concur in this judgment. If you've got ones where you've overstepped the bounds of rationality, you don't just take a broad brush and say, oh, don't worry, you're operating under pressure. My Lord, what your Lordship must remember, and this is where I started the argument. In our founding affidavit, we point out to your Lordship that there is no parliamentary oversight. There is nobody here that's going to act as a check and a balance to the minister who's exercising this executive power, she calls it, or under administrative law, other than this court. Nobody else. So she becomes a law unto herself unless the courts are the check and the balance. And that is why, not only on the rationality, but relevance to mootness, your Lordship has to declare things done which were unlawful, because nobody, Parliament doesn't interfere. That's the big argument. There are pending bills in Parliament where, amongst others, the Vryheids Front have suggested there be a move to that. My Lord, that is what they did in the UK. They put up special legislation to deal with the pandemic, but it still has parliamentary oversight. This has no oversight whatsoever. The only oversight is the court. So what we've got to do, my Lord, ultimately, is your Lordship has to look at it and say, is it rational or is it not? In the same way as the courts have set aside, retrospectively, the ban on hot meals, as the Supreme Court of Appeal did, and exercise, and the ban on cigarettes. Why is that important? Well, as we know, my Lord, cigarettes were initially banned. BATSA brings their case. They're then successful, and then the minister no longer bans cigarettes. So your Lordship's judgment is highly important, and it's very important to assess what is reasonable and what isn't. So, my Lord, to cut through the argument, we deal with taxis in our heads of argument at paragraph 140, at 054-64 is the page number. Your Lordship will see that they concede that allowing taxis to operate is irrational, and we give the references there in our heads. But they don't give any explanation for that. They just say, well, we're allowing it. But Lord, that is because of political pressure. There's no other rational explanation for it. So they allow this to happen. Then we have a situation with gambling, my Lord. There can be no difference between gambling, and we've cited articles in foreign courts where the courts say there can be no difference, and that's in particular in the American case, my Lord, in the minority judgments, where they say standing next to each other at the crapshoot or at the roulette wheel is no different, they say, to standing at church, and therefore there shouldn't be this distinction. It's not rational. My Lord, we deal with gyms and we deal with restaurants. Your Lordship put a question to my old friend, isn't it different at a restaurant? With respect, my Lord, it must be worse at a restaurant. We all know what happens at restaurants. Loud music is played and people speak loudly. What we put up in our papers, my Lord, is a study that says singing doesn't increase, because that's what the minister says, but you sing. Singing doesn't increase the transmissibility. It depends on how loud you sing and how loud you speak. So, and if you're wearing masks, that's going to be prevented anyway. So at the end of the day, when we look at the papers, and I can give your Lordship the references, we deal with this in detail with reference to facts, for which there's no proper response. But you'll see it at 001-100 to 106, in particular at paragraph 210. We deal with it at 011-113 at paragraph 244, and we set out the reasons why there's less risk in a church. Lord, we deal with it in reply at 010-5 and onwards. We deal at 010-252, religious gatherings versus supermarkets and workplaces. We deal with at 010-253 with taxis and aircraft. And we deal in our papers at 010-274. So, my Lord, we respectfully submit that there is tremendous detail where we put up facts and circumstances as to why these other activities are no more risky or less risky than meeting at religious gatherings. In fact, the opposite, and the same as what the Muslim Lawyers Association have done. And we give your lordship details. And we reference in our heads of argument, page 46, 103, the international law experience, the foreign cases, and from pages 52 to 56, my lord. Your lordship will see how the judgments internationally have similarly dealt with these questions. And all of them, my lord, all of them come to the conclusion that it's irrational to ban all the ones we've referred to. There are very few cases of which we were able to find in foreign courts where they've said an absolute ban is acceptable. France, Germany, all around the world, nobody accepts in the general world that their absolute bans are acceptable for religious gatherings. Because what that brings your lordship to is ultimately, if there's a less restrictive means to allow people to gather as demonstrated by these other events, then you have to afford those same rights to religion. If you say people can't sing, well then fine, pass a regulation that says so. But that doesn't mean you can't gather. So, my lord, at the end of the day, we submit that it's demonstrative that there is an irrationality. I referred your lordship, for instance, to the situation that happened in July 21, where suddenly ministers can have meetings for purposes of emergency services, but not otherwise, again demonstrating the irrationality. And ultimately, my lord, I referred your lordship to the anecdotal evidence. All the minister relies on, your lordship will find at 011-62, paragraph 88 of the papers. It is perhaps appropriate that I just briefly take your lordship there. It's 011-62, my lord, and we'll direct your lordship there. Your lordship will see that what we deal with is the only three anecdotal examples, it's from paragraph 88 onwards, which the minister mentions. Now, your lordship referred, and you said there was the people coming internationally and they were part of this spreading. Lord, that was a meeting in Bloemfontein, as we deal with at 88.1, on the 9th to the 11th of March. That was prior to any regulations. Nobody had said you can't meet. Nobody had suggested that it was safe or unsafe. International borders hadn't even been shut yet. No regulations had been promulgated. So it's not an appropriate example, my lord, because after that regulations come in, and not one example after the regulations have come in has been put up in the papers to say there was a super spreader event at this church or that church. Which brings us to another point, my lord. The minister herself defines a super spreader event as a mass gathering where there are no protocols in place. We deal with that in our heads. Once she accepts that, any gathering for worship is not a super spreader event because there are protocols in place, like in all the others, and there are limits. My lord, we deal in 88.2 with the Malaysia point. That again took place 27 February to 1 March. News reports indicate this was a 4-day mass meeting hosted by an Islamic missionary movement in Kuala Lumpur, where 16,000 people were there, my lord. That is not an example that is opposite where we're dealing with the present situation. And there's a newspaper article that they rely on. And it was only afterwards that these kind of gatherings were banned. And the third example, the anecdotal evidence, your lordship will see, is the US choir practice, my lord.
Mr. Botha, you should be wrapping up, eh?
I will wrap up, my lord, shortly. I'm going to need about another 10 minutes. The point I make, I commend this to your lord, we deal with each of these. This was before, again, there was no social distancing, a choir meeting where people sat next to each other and we give the facts. And we deal with the South Korean example, which is a red herring. And as we explain, my lord, all of this happened before the regulations were in place, and we deal with those facts. So what are the facts before your lordship? Those are the facts before your lordship. And what happens is subsequent to that, the churches are opened up and before the restaurants and then subsequently shut again. My lord, that brings us, that's for the rationality argument. I've dealt with the fact that you can meet in a restaurant or otherwise, and we submit they are flawed. Lord, briefly on the mootness argument, I've already addressed clearly, my lord, with reference to the government gazettes of which you may take judicial notice. Briefly on judicial notice, and I'll keep it very brief. The requirements for your lordship to take judicial notice are two things. Your lordship can take judicial notice of legal matters, such as government gazettes. The judgment in that regard is S versus Di Stefano, D-I-S-T-F-A-N-O, 1977-1 of the South African Law Reports, SA 770C, a decision of the Cape Provincial Division. And he, with reference to the Criminal Procedure Act, and it's similar to, and it's in line with Section 5 of the Civil Proceedings Evidence Act, which says proof of law, anything published in official publications, judicial notice shall be taken of any law or government notice or of any other matter which has been published in the Gazette. So once it's in the Gazette, my lord, your lordship can take notice of it. That's judicial notice as regards the law. Then, my lord, there's judicial notice as regards facts. The requirements of that are that the facts must be notorious or so well known as being incapable of dispute among reasonably informed and educated people. They must be locally known facts, i.e. where the court sits, facts readily ascertainable from sources of indisputable accuracy, and political and constitutional matters such as the constitutional status and the history of South Africa. That was dealt with recently in a decision in the Free State, MEC, Department of Police, Roads and Transport, Free State versus Roberts, 2020, Volume 3, SA 478, decision of the FB, Free State, Bloemfontein Court, my lord. It explains that exactly that test that I've described to your lordship. And it goes on to say in the digital age, it has been made easier to ascertain facts, and the court may take judicial notice of such material when it's readily available and reliable, however it may come to the court's attention. Emphasis must be on the material's availability and reliability, recognizing that in our technological era, information where in the past have been unearthed only after lengthy investigation may now be readily available. So I commend that, and that, my lord, is in line with the Supreme Court of Appeals judgment in Grootkaal Community and Others versus Botha at 2019, Volume 2, SA 128, SCA. 2019, Volume 2, SA 128, SCA. So, my lord, do they need to be notorious? They need to be readily available. The government gazettes anywhere before your lordship. What it demonstrates is the threat hanging over people's heads. My lord, the AfriForum judgment, which we've referred to and also uploaded, there, the distribution of the funds had already taken place. The court says, I can't set aside and review the decision, but it says, I'm going to give a declarator. Ultimately, my lord, there were a number of cases we've referred to Pridwin, P-R-I-D-W-I-N. It's in our authorities bundle at 055-5. Your lordship will see that in that case, that was about a private school, and it was discrimination and, again, religious matters. And it refers to Pillay, which is also, I've referred to your lordship at 055-789. In both of those matters, these are religious freedom matters. The court found it was in the interest of justice, and that's the test. Is it in the interest of justice? And that's what your lordship has got to weigh up. The test is at paragraphs 48 to 59 of Pridwin, and at paragraphs 32 and 35 in particular of the Pillay judgment. And in both instances, the court finds, due to the nature of the right, due to the circumstances, it is appropriate, even if it's moot, because there they'd left the school, they were no longer there to deal with the matter. So, my lord, especially, and that's where I argue the mootness, it's in the context of religious freedom. And in the foreign law cases, from paragraph 60 of our heads, my lord, we set out a number of foreign law cases where the courts found it's not moot, because there's this constantly moving goalposts. And because of the interests of justice and because of the importance of religious rights and freedoms. Your lordship will see that we summarize that amongst others at page 05433 onwards, and in particular at 60.2, where it says it is of grave importance, the interests of justice, and especially since they involve government's respect for and protection of fundamental human rights during a time of national disaster. Those are amongst others the reasons given in the foreign cases, which include the Roman Catholic Diocese case I've referred to, and Reverend Dr. William J.U. Phillip, which was a decision of a court in Scotland, my lord. So those are examples of foreign law cases where they come to the same conclusion. Lord, that brings us to section 36 and the policy issues. As far as that is concerned, my lord, policy is nothing more, and I'm going to be brief. It's dealt with in paragraph 46 onwards in the SR judgment. Even if they contend it's a policy approach, it doesn't mean that they're not subject to oversight. It's not about, as they seem to think, that means picking winners and losers. That's not what the cases say. I commend to your lordship paragraph 44 of the AfriForum judgment as well in that regard. And ultimately, my lord, the issue here, as I've submitted earlier, is this is the vehicle the minister has chosen. She could have chosen new legislation. She could have chosen different legislation. In the absence of any parliamentary oversight, it can hardly be suggested that a policy can't be reviewed in these circumstances. They've chosen the DMA, the courts have reviewed it, they reviewed it in AfriForum, and they did so in the SR judgment. So, my lord, the rationality analysis remains. Your lordship will see that, and that's also the same in the foreign courts. Your lordship will see that in our heads, paragraph 103, page 054-48. We deal with, in numerous cases, the excuse about these polycentric matters overseas. They've also dealt with them and said they can interfere. So insofar as the Constitution enjoins your lordship in interpreting fundamental rights, your lordship would do so. That brings me to consultation, my lord. Consultation we deal with in two places in our heads. Your lordship will see that we deal with it up front in the heads of argument, in the central arguments. We deal with paragraph 12 in particular of the relief sought, and we explain to your lordship the nature of consultation. I would draw to your lordship's attention the judgments, and your lordship asked my learned friend, what is the basis for the consultation? So, my lord, the authorities in that regard, and this is very important, it's Scalabrini, my lord. We deal with it in footnote 63. It's at page 054-21. And that was followed in the Somali judgment. They're both Supreme Court of Appeal cases. And what those judgments tell your lordship is that when you're dealing with a consultation issue, where there's a matter on which, and in fact, they're also in our authorities bundle. Perhaps I should just take your lordship there briefly, my lord. I'll be 3 more minutes on this and probably 5 minutes on the other matter.
You're over speaking and you say the same, some of the things you just over elaborate, but yes, you must wrap up now. It's more than an hour.
Yes, my lord. If your lordship will have regard to the Scalabrini judgment, his lordship, Mr. Justice Nugent, finds that where there is it's at paragraph 69 to 72 of the judgment, your lordship will find it in the authority bundle. It starts at 055-874. And at paragraph 69 to 72, his lordship, Mr. Justice Nugent, says the following. It says, nonetheless, at paragraph 68, he starts, indeed, circumstances, rational decision-making calls for interested persons to be heard. And he explains that. He then says at 69 that the process by which a decision is taken, and this was a legality case, my lord, so you still needed consultation. A contradiction decision on the merits of the matter under consideration might itself be impeached for want of rationality. And he refers to the Democratic Alliance case. Then he says, in this case, at paragraph 70, I'm reading at 055-875. In this case, the Director General was pertinently aware that there were a number of organizations, including the Scalabrini Center, with long experience and special expertise in dealing with asylum seekers in Cape Town. His representative, Mr. Yusuf, had specifically undertaken to consult with those organizations on any proposal to close the Cape Town office. In the absence of any explanation for not having done so, I'm left to infer that the Director General's failure to hear what they might have to say when deciding whether that office was necessary, fulfilling the purpose of the Act, was not founded on reason and was arbitrary. Even more so, to stage what was in truth the charade that could only have misled interested parties as to the intention of the authorities, which was inconsistent with responsiveness, participation, and transparency. So the test, my lord, is that if you're dealing with an entity with specialized experience, with long experience, it's appropriate to consult with them. It's not to say that the failure to consult with any interested party will set it aside, but such duty, the learned judge summarizes in paragraph 72, will arise only in circumstances where it would be rational to take the decision without such consultation, because of the special knowledge of the person or organization to be consulted of which the decision maker is aware. The suggestion that they were not aware of us, my lord, doesn't go up. That's blatantly untrue. We've demonstrated that we consulted on 2 occasions, but whenever they wanted to pass regulations such as these, they don't consult us. We demonstrated, my lord, that at various times there were between 15.5 and 18.5 million constituents that were represented by freedom of religion. Fundamentally, freedom of religion is the kind of entity you would need to consult with and would want to consult with. So, my lord, at the end of the day, we also sent letters, and I can give your lordship the references where it's dealt with in the papers at 001-107 and on. 010-261 and on. 010-18 and on. 010-261 and on. Same 268 at para 99.1 and on. So, my lord, at 001-81 and on, and a paragraph 166. The difference was, my lord, we'd been writing letters. From the moment that they announced the risk-adjusted strategy, we were recognized. There was an express undertaking by the minister's deputy that we'd be included. That's at 001-81, paragraph 158. We're no distinguishable than the Scalabrini case. There was an undertaking. We had a personal meeting with the minister, 001-84, paragraph 166. And we were included with meetings with the president and thereafter excluded. On the 1st of September 2020, first meeting on 2 September 2020, that's 001-89, paragraph 176. And in the second meeting on the 17th of March 2021, my lord, in the gap, we met before with the president and after with the president. That's at 010236, paragraph 11, and it's dealt with in our heads, paragraph 66, my lord, and also under the particular heading of dealing with the consultation approach. In those circumstances, there is no doubt, you'll find it at 054-68 of our heads, it's chapter 10. There's absolutely no doubt that there needed to be consultation, my lord, with 4SA. If they consulted with us, they could have looked at reasonable ways of limiting the restrictions. And my lord, that with respect is dispositive of the issue of consultation based on the authorities. The last topic, my lord, is essential service workers. Ultimately, my lord, they are defined in terms of Annexure D. I probably should just take your lordship to the regulations. The regulations your lordship will find at the definition of essential services is at 055-1635. 055-1635. Your lordship's being directed to the page. There's a Gazette bundle there, my lord. Your lordship will see the definition of essential services. The definition means the services listed in Annexure D. Lord, if you could then go to 055-1665, 055-1665. There your lordship will find the definition, or what is in table D. I'm taking your lordship there now, I'm directing your lordship to the page. What your lordship will see is it says essential and permitted services referred to in 16.3 of the regulation shall refer to the list of essential services as set out in B below, and, see my lord, the and, such other services are set out in alert level 4, and where technological, industrial, structural or similar requirement of the service necessitates a continuous or shift operation as set out in directions as set out below. And look at B. Essential services means the services as defined in section 213 of the Labour Relations Act. That's your lordship's committee that your lordship chaired, and designated in terms of section 71(8) of the Labour Relations Act, and which designation remains valid of this regulation and as listed below. So they then list a specific list of services, which include medical health practitioners, outsourced administration, the insurance environment. These are matters, my lord, that would not be covered by your lordship's committee, because these are private entities, not essential services such as the police, nurses, etc. There are therefore two pathways to essential services. The one pathway is through the committee that your lordship chaired. The other pathway is being included on Annexure B. For instance, wholesale and retail stores for stocking, production and sale of goods, critical jobs for essential government services, essential municipal services, goes on, care services, social relief of distress provided to older persons, mentally ill persons with disabilities, funeral and cremation services, newspapers, my lord, that's not under your committee. Production and sale of chemicals, that would not be under your committee. Essential gold refinery, private security services, etc., etc. My lord, it goes on for 2 pages. And if your lordship looks, even implementation of payroll systems, that wouldn't be your lordship's committee. These people didn't apply to your lordship's committee to say, this, please make me an essential service worker. So there are clearly 2 channels on a proper interpretation. It actually goes for 3 pages. It even goes over the next page. And in addition, my lord, as we set out in our heads, where we deal with the importance of the classification, that's chapter 9 of our head 05466. And we dealt with it also at the beginning of the heads, my lord, in that top section. We point out that the president actually promised to make us essential service workers in a letter. And in those circumstances, it must surely be irrational to refuse to allow us, and the ultra vires argument is simply unsuccessful. Lord, finally, just in regard to the relief, therefore, we submit, your lordship will find the amended notice of motion. There was much debate about it yesterday. Your lordship will find it at 001-563. That is the amendment. Your lordship will remember there was an objection. There was an objection only to paragraph 7, where we sought to expand the relief. We didn't do so in the end. There was no debate about my learned friend about supplementary affidavits, my learned friend's predecessor, Ms. Pillay. What the debate was about was that we could file our amendment because we weren't going to pursue that. Paragraph 13. What's the difference
between the relief you seek and the other parties?
My lord, only the additional relief that we seek is the consultation. So paragraph 7, if your lordship goes to 011, the 563 that I've just referred your lordship to, and I can take your lordship to it very briefly. It's part B that your lordship needs to look at. You don't need to look at part A. I'm directing your lordship to the page 001-563. Your lordship will see the first part is part A. We've already had that fight. Part B, your lordship will find commencing at page, I'm directing your lordship there now, 001-568. Your lordship will see declaring the regulations published on those dates invalid. So we say we're inconsistent words, retrospective and invalid. So that's the declarator. Paragraph 8, my lord, those were the subsequent regulations. We're not persisting with that, as we made clear in our heads. We explained this all, my lord, in the introduction to our heads as to what relief we're pursuing. The 9 and 10, the religious leaders, paragraph 10, my lord, is declaring the failure to include religious leaders. That is important as a specific category of essential services. That's what we seek. That's different. So the failure, what you're going to do is declare the failure to declare us essential service workers as unconstitutional and invalid. My lord, then we deal with
declare whom?
The religious workers, my lord.
Does it include all the religious workers?
No, it says religious leaders.
Yeah.
Religious leaders, my lord, which is a phrase, as your lordship would have seen from the government gazette, that the government themselves have used.
Okay.
So that was the one that they used in the 14 July government gazette, for instance, to say you can meet in front of a religious leader. So there can be no objection to that. A religious leader is clear. It's like saying a psychologist or somebody. And so we submit that paragraph 11, that it would be appropriate for your lordship under just and equitable to order them to include us as a specific category as the list of essential services. Now, my lord, paragraph 12 needs some explanation. If your lordship finds that we're correct, that there should have been consultation before the promulgation of December regulations and the January regulations, and your lordship put, and I didn't address this earlier, but your lordship put to one of my learned friends, but the minister is acting under great time constraints. With respect, as we set out with respect in our heads, dealing with the Eastern Cape situation, my lord, your lordship will see, it was Ms. Martin that you put it to. In the Eastern Cape situation, they saw the peak of the infection coming for miles. My lord, we deal with that at 054 to 24 of our heads. And then we deal with that in more detail later at paragraph 142 at 054, 65 of the heads. Your lordship will note that it was common cause what was happening. And at that stage, there was a wave, and the second wave in PE had already, because that was, your lordship will recall, the Eastern Cape was the first part to get the second wave. That was in early September. Based on the statistics, they knew where that was going, and that wave had already peaked by November 2020. They only put the regulations in December, towards the latter part of December, 29th of December, once they'd already passed the peak. So we say you had months to consult. There's no reason why you could not have consulted. And if your lordship finds with us, as we make these arguments in the heads, that if they should have and they could have consulted, then your lordship would set aside the regulations for procedural irregularity as dealt with in SL. In SL, they found that the time for consultation was too short because they were dealing with the RAS at that stage, but that was under the first wave, my lord. When we have the second wave, as your lordship sees from that diagram I referred your lordship to that comes off Google, that the minister put in a supplementary affidavit, you have months to prepare for these waves. Everybody tells us the waves are coming. They consulted with us in September and in March, but they don't consult in between. That is a self-standing ground upon which your lordship will set aside the regulations. What we're asking for under Pre 12 is an additional item of relief where we submit it is appropriate to declare that we are a party who they should consult with, but your lordship doesn't need to find that in order to set aside the regulations for the absence of consultation. So your lordship, that's the context of 12. So my lord, those are the submissions. 13 and 14, as we explained in the heads, that is to deal with the Eastern Cape scenario. We admit that we found difficulty in formulating it. That is to provide guidance where we say that they should follow the data in respect to the spread of COVID. But your lordship may find for us under paragraph 7 without granting that additional relief. That would be part of just and equitable relief. So that's the relief that's different in ours compared to the other parties, my lord. Unless there's anything else, my lord, I believe those are my submissions.
I think it was far too long. I think I should have cut you down just to over-elaborate, but yes, there's nothing further.
Thank you.
Mr. Mokgakabe?
Thank you, my lord.
What do you want to do? Do you want to start straight away?
My lord, let me make the following submissions, my lord. As it appears clear that the applicants have taken more than a day in presenting their arguments. And my lord, I would like to find out from your lordship that if your lordship's offer for extending the matter to Thursday is still available, then your lordship should grant us the indulgence to commence our submissions tomorrow morning.
Why tomorrow morning? We've got now 1.5 hours for today at least. So if we can start today, we can give you a 10 minutes break and then we can start and work for an hour. And then we'll see how far we go tomorrow if you finish. One thing is quite clear, they're not going to get long replies. I don't think Mr. Botha...
You may never know, my lord. I mean, Mr. Botha said it's going to be 45 minutes, my lord. He went for more than 2 hours.
Now, only Mr. Botha did that. The others kept to their times. Miss Martins took a bit longer this morning because I engaged her.
And Mr. Botha said 30 minutes, but went for more than 30 minutes, my lord.
Yes, because I questioned him a bit too much, and I realized that. And there was quite a bit of repetition, I accept that. But under replies, I'll keep them tight. if we can start today, you will definitely get as long as you need. If you don't finish tomorrow, if we start today and you don't finish tomorrow, then I'll give you Thursday. So yes, I'll give you more than a day if you want. But that means all the more reason for us to begin now, isn't it?
Well, I mean, if your lordship says so,
Because
I was asked for that
the
if I
longer the
start
thing
tomorrow.
takes to do, the more the reason to begin at once.
Yes,
Wouldn't that be the right way to approach this?
yes. Now I was saying,
So
my lord,
let's give us 10 minutes to catch our breath, grab a glass of water, and you can give 1 hour today, and then you'll continue tomorrow at 10 a.m.
okay. If that is so, my lord's fine. Otherwise, I didn't want to have, I mean, stop and starts in making my submissions in that
But we're
regard.
going to stop and start for lunch tomorrow, and you're going to be busy. You will come back after lunch. You're going to stop and start for tea break. So let's just treat this as if we stop and start for dinner, but it was or a long lunch. If you want
As a court pleases, my lord.
a long lunch.
As a court
Yeah,
pleases.
let's try and make
It is important, my lord, that in fact the hearing of this matter is expedited, and that in fact, my lord, depending on the submissions made, I did foresee that the applicants would go over the, I mean, allocated time. Yes, I anticipate that the court will maybe interrupt and maybe stop them from. Yes,
I think the only I should have done that a bit more. Some of the points were already made, but the first two speakers were very much in their time. The third one, I interfered with him. And then the fourth one took about 2.5 hours. That was more than too much. But it's done now. Let's just move on, and you'll start in 10 minutes or 15 minutes, and then see how far you go. Even if you only point out the introduction and say where you go, and point out the roadmap for me, then that's fine. Even if we get that, and then we move on from there till tomorrow, and we don't finish tomorrow, we take it there from Mr. Botha, Mr. Botha, Ms. Engelbrecht, Ms. Martins. Please be informed you are not going to get long times for replies. Your case has already been made.
No problem.
Okay, Mr. Botha. Okay. We'll then just adjourn for 10 minutes to just catch a breath for Mr. Mokgakabe to get to see his documents and then come back to us. Okay, Mr.
As a court pleases, my lord.
Thank you, Mr. Mokgakabe. We'll stand down for a few minutes, for 10 minutes.
Thank you, my lord.
Boitumelo?
Or Judge, I say I will call you. I'm not sure whether he's back. I'll call you as soon as he comes.
Thank you.
Okay, Judge.
say, my lord, up front, that this case, my lord, has got to deal with the challenge to the constitutionality of the December 2020 regulations, as well as the January 2021 regulations. In essence, my lord, this case has to deal with challenging the regulations by the minister, prohibiting, amongst others, my lord, faith-based gathering or religious gatherings. In these regulations, my lord, the minister not only banned religious gatherings, but also, banned social gatherings, political gatherings, and gatherings of traditional council meetings. So, in a nutshell, my lord, what you have to do here and what the court has to decide, it's only one issue, my lord. The challenge to the constitutionality of the prohibition of faith-based gathering, my lord, as contained in these regulations, which have been termed by the applicants as the impugned regulations. My lord, for the record, these regulations, my lord, the impugned regulations, my lord, are no longer in force, no longer operative. They have been superseded and replaced by a series of regulations since the applications were launched. Just, my lord, to put the matter into perspective, the 29th December, which I'll refer to as the December 2020 regulations, my lord, prohibited the holding of, amongst other things, religious gatherings for a period of 2 weeks, subject to the minister reviewing the situation. When the 2 week elapsed, my lord, then these regulations, my lord, at that time then were replaced or superseded by the January 2021 regulations, my lord, which also imposed a total ban on, amongst other things, religious gatherings, my lord. When the matter, my lord, served before Judge De Villiers on the 2nd of February, the prohibition on religious gathering was uplifted by the minister.
When
in terms of
did you say when did it serve before Judge?
On the 2nd of February this year, my lord.
Yes.
On the 2nd of February this year, my lord.
Yes.
Then the prohibition on these religious gatherings was uplifted or removed, my lord, in terms of the regulation which were promulgated on the 1st of February 2021. This then necessitated the applicants to forego Part A of the relief as moot. What I will have to address the court, my lord, is that it is amazing as to if ever the basis of the challenge to the regulations was predicated on the total prohibition of religious gatherings, my lord. Simultaneously, likewise, my lord, the relief, sought in terms of...
Ms. Engelbrecht, have you got your hand up?
I do, my lord, and I don't want to interrupt my learned friend's flow, but he makes a submission to you to which I must object, that the applicants did not proceed on the 2nd of February on the basis that the matter was moot. The correct position is that the matter was now...
Give a chance to reply on that.
This is not a matter of reply, my lord. It is simply a matter on the basis that it's a question of urgency, not mootness. It's important that the submissions are not made on the basis that my clients ever made any submission on mootness on 2 February. It was a question of urgency only, and that's the correct position in law.
But then Part A is not. If that is so, then Part A. Then is Part A still before us?
Lord, but Part A is not before you.
Why is Part A not before us?
My Lord, this is a question of initially my clients came to court to seek urgent relief.
Right. So is Part A now drawn into Part B? So you don't have to go for Part A. Because you're going in for Part B.
That is correct, my Lord. And it's just a simple point that I want to raise the objection early, that my learned friend is not misled so as to think, after all of the submissions made, that somehow the matter was not heard as to Part A on the basis of a mootness question. It was an urgency question. And I just wanted to make that point absolutely clear.
Thank you, Mr. Engelbrecht. Point taken. Mr. Mokgakabe?
My Lord, I would ask Mrs. Engelbrecht, my Lord, to have a look at the pleadings before she makes this kind of objections. Because, my Lord, I have the order which was granted by Judge De Villiers on the 2nd of February, my Lord. This order, my Lord, I think if the court can have regard, my Lord, it's a uniform, identical order in respect of all 4 applications, my Lord. What I have, my Lord,
where can I find it, Mr. Mokgakabe?
I have here the order as appears in the MLA matter, my Lord.
Okay.
It's at page
reference 001. 001.
What? Oh, my Lord, apparently you have been directed to the order, my Lord, by my juniors, my Lord.
Yes.
My Lord, if you look at paragraph 2 of this order, my Lord, is the court there, my Lord?
Such a relief has become moot.
It says Part A of the application under case numbers 2021-0143, 2021-3344, and 2021-261 are removed from the agent roll on the basis that such relief has become moot. See, my Lord? Yes. So the objection was in any event misplaced, my Lord. As I was saying, my Lord, similarly, my Lord, as the basis of the challenge is the prohibition, total prohibition on religious gathering, Part B also became moot or ought to have become moot at that stage, my Lord. Because in any event, Part B is predicated on challenging the constitutionality of prohibiting social religious gatherings outright, my Lord. For reasons unknown, the matter was allowed to proceed, my Lord. This then, my Lord, the upshot, my Lord, is that the relief, my Lord, which is sought by the applicant has become moot, my Lord, as the both impugned regulations at the time, I mean, that the application served before Ms. Justice De Villiers were replaced and superseded by the February regulations, my Lord. Therefore, my Lord, that being so, my Lord, I will then proceed to address the court on the question of mootness. My Lord, this the submission on mootness, my Lord,
Mr. Botha? Yes, carry on. It was Mr. Botha's mic which was on.
Yes, my lord.
My lord, I just want to point out that part A of what my learned friend read out doesn't have the MLA case number. So that the MLA case number is 20212619, and it's no mention of that. No. Sorry, it's 20213002.
We put it on screen.
So yes, 20. It's on screen. My learned friend said this is the MLA order. I'm not sure.
All right, thank you, Mr. Botha.
So MLA's case is not mentioned.
Mr. Botha?
No.
Mr. Botha, what happened to your party?
I don't think we had a part A, my lord. We just had our notice of motion.
No, yes.
Is quite clear. Sorry. Just switch to.
All right.
Our notice of motion is an 001-1, and we just asked for normal relief, final relief in the urgent court.
Thank you. Thank you, Mr. Botha.
Well, my lord, I think Mr. Botha is correct, my lord.
Please continue. I'm going to also ask all the others to try not to intervene and disrupt Mr. Mokgakabe's flow of thought. I appreciate trying to correct him here and there, but if possible, please try and leave Mr. Mokgakabe or give Mr. Mokgakabe the space to develop his argument. Mr. Mokgakabe, he just responded to the fact that the MLA one has not been declared moot.
Yes, my lord. But my lord, the fact is the order is the same, my lord. In any event, my lord, I think, my lord, if then, I mean, I want to at least thank Mr. Botha for bringing this thing to my attention, because it has already also skipped, my attention, my lord. My lord, if you look at prayer 3 on this order, my lord, right?
Mr. Botha's prayer.
Yeah, it relates to Mr. Botha's case. It says it is removed from the urgent role to be heard with Part B of the other consolidated applications. Then comes prayer 4, my lord. It says no finding is made in respect of the mootness of Part B of the applications under the 3 cases, that is SANCF, that is FOSA, and that is Solidariteit, or the relief sought in respect of Mr. Botha's case, application, my lord. Now, this order means that the finding is not made, and the finding then, my lord, is left for this court to decide the issue on the issue of mootness. So the court will be entitled, my lord, to determine the issue of mootness, likewise as per the terms of prayer 4 of the order of Justice de Villiers. That being so, my lord, then I will then, my lord, proceed to address the court on mootness. But what I want the court to keep at the back of the court's mind, my lord, is that at the time that the applications were launched, the December 2020 regulations were no longer in force. At the time that the matter served before Mr. Justice de Villiers, even the January, regulations were no longer in force, because they have been superseded by the February regulations. In other words, my lord, the January regulations superseded the December regulations. The February regulations superseded the January regulations. So then, at that time, the regulations were not in force, and therefore the matter was moot. My lord, that being so, my lord, I then want to address the court about the doctrine or principle of mootness, my lord. It is tried, my lord, that mootness arises when a matter no longer presents a live or existing controversy, which is basically, my lord, based on the notion, as you said, that judicial resources ought to be utilized efficiently and should not be dedicated to advisory opinions or abstract propositions of law, and the courts should avoid deciding matters that are abstract, academic, or hypothetical, my lord. My lord, in our heads, we refer to the case of Buthin, which was decided by NSCJ, right? And we also, my lord, refer to the jurisprudence of the Constitutional Court in enunciating this aspect of mootness, my lord. My lord, the cases are regarded, in the matter of JT Publishing as a Minister of Safety and Security, the principle of mootness was espoused as to say a case is moot and therefore not justiciable. If it no longer presents a live or existing controversy, and the court should avoid giving advisory opinions. The court, however, my lord, it will say also has a discretion that in the interest of justice here matter, even if it is moot, if any order that the court will make will have some practical effect either on the parties or on others, my lord. On that point, my lord, I interpose to point out that, as the court also alluded to earlier on, as these regulations are no longer in place in force, what is there to be set aside? Can the court set aside or deal with regulations which have long, it's almost now 10 months, my lord, down the line, been superseded? However, my lord, a question obviously doesn't rest there. The question is, what is, in the interest of justice, my lord? In the Langebeck case, my lord, the Constitutional Court found that, which dealt with the issue, my lord, of the elections of 2000, December 2000, local elections of December 2000, and a matter served before court in February, and I think judgment was delivered, I think, my lord, 4 months down the line. The Constitutional Court found that there was no live controversy between the parties because the elections were already over and there was no suggestion that any order that the court will make might have any impact on the parties, that the dispute between the parties was moot, and given the future cases may nevertheless present a different factual matrix, the court held that no purpose will be served, my lord, in resolving the dispute, neither was there any practical value in deciding the matter, my lord. We also submit, my lord, that any declaration of constitutional invalidity would not serve any practical effect or purpose. It will only be done for pure academic interest and will have no practical application. More importantly, as any declaration as to the conservative proposed regulation will not affect litigants either within or beyond the confines of this court. My lord, then we refer to the case of AfriForum that says that the fact that a case is moot doesn't bar the court from determining the justiciability of the issues at hand. But more importantly, my lord, we want to state that, my lord, that as set out, my lord, in paragraph 81 of our heads, that given that the constitutionality of these regulations are not before this court, it is not permissible for this court to pronounce in any shape or form on whether these regulations pass constitutional muster, my lord. And that therefore, in fact, the challenge is moot. And that the applicants, my lord, have fallen far short.
The constitutionality of the regulations is not before the court. In other words, putting aside the live controversy issue, they're challenging the regulations on the grounds that they've breached or infringed the constitutional right. Surely that places at the very heart of the whole case the issue of the constitutionality of the regulations.
Yes. Well, my lord, I mean, that also served in the Langebeck case that the local government, were also challenged on the basis of their constitutionality of I think there being only one voting station, and therefore, in fact, which impinged on the right of the voter to exercise their right to vote, their constitutional right to vote, my lord. So it is not something new before the court relating to a challenge based on constitutionality, my lord. My lord, I will then have my lord to refer the court, my lord, to the case, my lord, which is applicable and which is recent, relating to the factors which the court take into account in determining whether it will be in the interest of justice, my lord. My lord, in this regard, I would like to refer the court to the case of Normandin, my lord. It is also cited in on footnote 58 of our case, my lord, at page 831. This is a constitutional court matter, my lord, which dealt with the issue of mootness in the context of whereby, I mean, the appellant was challenging the acceptance by, I mean, under the Mineral and Resources Development Act of granting the respondent a right of exploration to search for petroleum on land, my lord. In a nutshell, my lord, is that the matter then went to serve before the High Court and then also went to the SCA, whereby the SCA found against the appellant on other grounds, my lord, not relevant to mootness. Then the appellant appealed to the Constitutional Court, and when the appeal was still pending in the Constitutional Court, then the respondent withdrew his application for this right of exploration, my lord, as well as attempted to have the matter settled, my lord. At the hearing of the matter, my lord, this appears, my lord, at, if I may just say so, at paragraph 26, where the court says, since the filing of the application on 10 July, there have been some key developments in the matter, and that the first application for exploration was withdrawn, and that the party attempted to settle the dispute. Then at the hearing, I mean, this issue was raised relating to the mootness of the proceedings and whether it is in the interest of justice to grant leave to appeal, my lord. The Normandin, as the appellant, submitted that the matter is not moot, that this court has a duty to adjudicate it, because the decision of the Constitutional Court of the SCA was incorrect and constitutes an incorrect binding precedent and would prejudice future litigants in respect of the same self matter. My lord, I mean, the question of the interest of justice then arose, my lord, and in this matter, my lord, Mr. Justice Mkandla, Justice Mkandla, my lord, who delivered an unanimous judgment of the Constitutional Court, I mean, traversed the issue of mootness and the interest of justice. In the 11th paragraph, my lord, is that he says, at paragraph 48 of the judgment, my lord.
Yeah.
Are you there, my lord?
Yeah, no, I'm not at the judgment. I'm just looking at your heads.
Oh.
No, I'm not reading the judgments. I just take a note of the judgment.
Oh, paragraph 48, man. Starting from paragraph 47, in any case.
If you need to just read it to me what he says.
Yes, he says, my lord. This court has held that it is axiomatic that mootness is not an absolute bar to the justiciability of an issue. This court may entertain an appeal even if moot where the interests of justice so require. The court has a discretionary power to entertain even admittedly moot issues, my lord. Then he went on, my lord, to determine what factors the court takes into account in determining whether, in fact, the interests of justice dictate that a moot matter should even be entertained or adjudicated upon, my lord. And he says at paragraph 50, my lord, this court has proffered further factors that ought to be considered when determining whether it is in the interest of justice to hear a moot matter. These include whether any order which it make will have some practical effect either on the parties or others, the nature and extent of the practical effect that may any possible order may have, the importance of the issue, the complexity of the issue, the fullness or others of the arguments advanced, and resolving the dispute between the different courts. Then the court says, as a point of departure in paragraph 52, an order by this court in this matter will not have a practical effect because, my lord, the application which formed the subject matter of the case had been withdrawn. Now that the Rhino's application has been withdrawn, there's nothing to set aside or interdict, my lord. Similarly, my lord, now that the regulations have been replaced or superseded, there is nothing, my lord, to set aside or review. There is no tribal issue to consider, and no party will receive any direct benefit or advantage as a result of an order on the merits of this case. Similarly, my lord, there is no beneficial or practical benefit that will ensue, my lord, even if the order, the matter is determined, either on the parties or on others, my lord. Further, my lord, the issue was, as it was submitted to the court, my lord, that there is a possibility that the very same impugned regulations may be reintroduced or reimposed sometime in the future, my lord, by the minister. On that aspect, my lord, the submission is there is no certainty or guarantee, my lord, that the determination thereof will be done on the same factual matrix. Given that, my lord, if ever it happens that they are reintroduced, my lord, there's no guarantee, my lord, or any certainty that they may be reintroduced in the same format, in the same wording, and with the same factual matrix, my lord. As such, my lord, that being the case, the interest of justice cannot dictate that the regulations, the matter be determined or the regulations are justiciable, my lord. There has been, my lord, that as matters currently stand, my lord, as matters currently stand, we are now at alert level 1, my lord, which has also been preceded by a series of regulations which have been replaced and or superseded, my lord. In terms of the situation as it currently stands, my lord, in terms of alert level 1, my lord, the situation is totally different as it was when the December regulations and the January regulations were promulgated. In terms of the current level 1 regulations, my lord, religious gatherings are allowed to a maximum of 750 persons or congregants indoors and 2,000 outdoors.
And that is since when?
Since the 1st of October, my lord.
So between between February and October, we had different levels of restrictions, didn't we?
Correct, my lord.
But religious or faith-based gatherings were still allowed.
When, my lord?
Between February till September. In fact, from February onwards till now.
My lord, they were allowed except for the June regulations, my lord.
Oh. In June, they were not allowed.
Yeah, in June, they were not allowed, my lord.
Right.
And then, my lord, I mean, that was the only, I mean, exception where they were not allowed because of the Delta variant, my lord, if I'm correct, my lord. However, when the Delta variant reached its peak, my lord, I mean, then, I mean, the restrictions were uplifted.
Now, that, where will I get that on the papers?
It's in the schedule, my lord.
In the schedule.
The schedule of regulation that accompanied, my lord, that further supplementary affidavit, which formed the basis of a skirmish between me
This one, yeah.
and Mr. Willis, my lord.
There's a schedule to this. I've got the affidavit.
There is also a schedule, my lord, which was uplifted on case lines. I think, my lord, my juniors will then obviously direct you to the schedule, my lord.
I don't get it, Mr. Okay.
Resolution on the schedule, man.
No, I haven't, but I'm sure you can continue. I'll still search for it.
Yes, my lord. In fact, my lord, just as a chronology, under level 5, my lord, all gatherings were prohibited. Same as under level 4, my lord.
Mm-hmm.
The gatherings, all gatherings were likewise, my lord, prohibited, except for certain, I mean, gatherings like funerals, etc., my lord. Then in terms of then when it comes to alert level 3, my lord, and then I think that's when in fact, I mean, the restrictions were uplifted. And then when it came to the June regulations, my lord, I mean, then I mean, the religious gatherings were prohibited. Mm-hmm. Then since then, my lord, I mean, the religious gatherings had been allowed. Up and until now, my lord, the religious gatherings have been allowed. Now, I mean, the argument has been proffered, my lord, that in fact, I mean, the issue was that, I mean, there was a total ban. But as matters currently stand in terms of reality, my lord, I mean, the situation is totally different. The issue is there is no practical value to the parties or any other persons in deciding this matter now, because as matters currently stand, my lord, religious gatherings are permitted with a higher number of people allowed to exercise.
Does your client accept that it is possible that they will reimpose, or probable that your clients will reimpose the prohibition?
Well, thank you for that question. I have to ask to respond to it maybe in a three-pronged fashion. Firstly, my lord, it may be a matter of speculation or hypothesis to give an exact answer with regard, to this issue, my lord. I don't want to find myself in a situation where I commit myself to an answer and it turned out that, in fact, my lord, I am incorrect. Secondly, my lord, even if there may be a possibility of the reintroduction thereof, there is also no certainty, my lord, or exactitude as to whether they'll be introduced in the same shape or format, my lord. They may be reintroduced, but not in the same format. And as such, it's a question of a different factual metrics relating to these regulations, my lord. And therefore, my lord, the determination of these regulations will not obviously, my lord, deal with what's going to happen in future, my lord. It is difficult to speculate about the future, my lord, that they will introduce in the same format of a total prohibition, or that, my lord, they may be introduced with some restrictions. Further, my lord, as I have said, one has to also have regard to the fact that, my lord, the issue of the introduction, if the possible reintroduction, because at that time that these regulations, my lord, were imposed, the government's rollout of the vaccination program had not yet started in December or January. It started sometimes, I think, in March. So, one has, if you want to take...
Now, that is not on the papers. And your client could have put that in a supplementary affidavit.
Yeah, but my lord, it's at a time that my client deposed to the affidavit, my lord, the rollout had not yet commenced, my lord. I think, the vaccine arrived after February, my lord, or during February, if my memory serves me well. But be that as it may, my lord, it's an issue which is, as I said, notorious, my lord, in that regard.
And there can be no dispute about it.
Yeah, there's no dispute about it, my lord. There's no dispute about it.
You started vaccinating.
Yes. That therefore, even if there is a possibility of a reintroduction of these regulations, my lord, they may not be reproduced or reintroduced, my lord, in the same format, shape, or form. It may be in a totally different form. But this being so, any order that the court may make will, in the circumstances, take into account the current level 1 regulations, as well as the vaccination rollout, will not have any practical effect or benefit to the parties or others now or in the future. Say, for example, my lord, the court strikes down these regulations, my lord, as matters currently stand. Of what practical value or benefit will it have to the applicants? Because in any event, as matters currently stand, the prohibition has been uplifted. The number of the congregants has been increased, my lord. So it will not have any practical effect or benefit to the applicants, their followers, or any other persons, neither now nor in the future, my lord. The point is, my lord, as we make it in our heads, and as I want to reiterate, as the regulations are no longer there, there is nothing in existence. There's nothing to strike out or to declare, invalid or
now,
to review.
on the questions of
My Lord.
Declaring whether the fundamental right to religion or religious practice was flouted. Now that they accept has happened, was infringed. If we declare that, as they say they want done, your client in fact has not challenged that. But then they say one step further, they say, your client has failed to justify why it had to do so. And your client has failed to meet the Section 36 limitations of right, the test applicable to Section 36 on limitations of rights. If we go ahead and do that and said for any reason that they were right, would that have any practical effect? Would that not be a guidance to your client on how to do it in future? To put the question differently.
Well, my Lord, that's basically, I mean, a separate inquiry, my Lord. The question, I mean, which we are faced with as matters stand, my Lord, is that, I mean, the applicants challenged the impugned regulations, and they're no longer there. And the question is whether are there any factors which are applicable as enunciated by the Constitutional Court, which will trigger the court exercise jurisdiction to entertain or determine, I mean, this matter, even though the matter is moot. We accept, my Lord, that it is common cause, if not undisputed, that the matter is moot.
It's not common cause that it's moot. It's not accepted that it's moot. They say it is still a live controversy. They, of course, rely on the July ones to show this, but not so much for saying that it's been reintroduced, but to show what actions government is taking and how government will be proceeding to deal with this ever-present disease. And that as long as this disease is around and as long as the minister has the powers to, in terms of the DMA, has the powers to introduce regulations that will regulate the social and other behaviors of people, this issue will still re-emerge.
But the fact is, my Lord,
if you take an election case, Mr. Mokgakabe,
yes,
the elections are gone.
yes,
We're not going to rerun those elections again.
yes.
And there's no chance that anything the court said on that case will have any impact on any future elections or anything. May or may not, I don't know, but in that one that was run before, I think it was Langeberg, if I'm not wrong.
That's Langeberg, man. That's correct, man. That's Langeberg.
The question of mootness is quite straightforward. But in a case like ours, is it not a little bit more complicated? That even though this issue, as it stood in December and January, is now gone, because that's the time at which your client took the decision based on the information and evidence available to your client then. The issue is your client may still take the same decision, albeit on different evidence. But she may come to that, but if she does it on different evidence, some of the issues will still be alive. Some of the issues will represent themselves.
Yes, but the question is, my Lord, firstly, my Lord, if I have to address the court, is that, as I understand the applicant's argument, is that they concede that the matter is moot. They concede that the regulations have been replaced. My Lord, they concede that. There's no way that they can, dispute that. They concede that the regulations, the impugned regulations, have been superseded. That's so, my Lord. And that as such, obviously, the matter is moot. However, they argue that due to the principle that says if it is in the interest of justice that the matter be heard, then the court should entertain the matter. Their argument, my lord, as I understand it, is that it is in the interest of justice that the matter be heard, even though moot, largely because there exists a possibility that the minister may in the future reintroduce the same regulations. I understand maybe in a nutshell that is their argument, my lord. So, my lord, as I submitted to the court, I made my submission to the court in this regard, my lord, and that as to, in fact, my lord, this argument cannot hold because it presupposes, my lord, implicit in this argument is that the very same regulations would once again surface in the same format, in the same shape, in the same wording. And that maybe the factual matrix will be the same. That cannot be so, my lord. It may resurface, my lord, but not in the same shape or format. It may resurface in the form of, say, religious gatherings are prohibited, are allowed, subject to a maximum of so many people, 50, 100, 200 for indoor gatherings, and maybe 500 or so for outdoor gatherings. So the court then will then be faced with a different set of facts, different regulation altogether vis-a-vis the impugned regulations. This very same exercise, my lord, this very same exercise might also, be indicative to the minister with regard to future conduct, my lord. So you cannot say, my lord, that therefore on those bases that of reintroduction, that therefore in fact the court jurisdiction or discretion is triggered, my lord. My lord, if I may be allowed, I want to deal with the ISO decision, my lord.
Is it on mootness?
Yes, my lord.
Or do you want to carry on with it tomorrow?
I can carry with it on tomorrow. If the lordship grants me that indulgence, my lord, I'll do so.
Tomorrow morning at 10 o'clock.
As the court pleases, my lord.
We can then continue with you with the ISO judgment, and then you can move on and on other aspects of your case later on.
As the court pleases, my lord.
Okay.
Thank you.
Thank you,
my lord.
Tomorrow at 10 a.m. Anybody has any problems with that?
Well, no difficulty, my lord. I just wanted to deliver your lord some good news. The good news, my lord, is the reply will be short because I'm unfortunately not available after today. I'm in another matter tomorrow, so I just wanted to apprise your lordship of that development.
Confessing to being the one who has lengthened the proceedings. Are you just confessing?
No, I'm not confessing.
Is this a mea culpa?
No, my lord, it's
maxima culpa.
It's lighthearted. I did warn your lordship I'd be a bit longer, but I'm generally short in reply. But your lordship won't get to find that out because I won't be here.
Who's replying on your behalf?
It'll be Mr. Crompton most likely, my lord, who will reply.
Is Mr. Willis not available?
Mr. Willis may well, but it depends on what we need to cover. Mr. Crompton deals with the data stuff more, but otherwise Mr. Willis will attend to it. But it's likely Mr. Crompton.
But it's Mr. Willis who leads Mr. Crompton.
He does, yes.
Right. Mr. Botha, is there anything you want to say? Nothing.
My lord, sorry, I may have the same difficulty. I will be in and out tomorrow, but I do have two juniors.
Are you also finding us boring? Mr. Botha, are you also finding us boring?
Sorry, you on mute.
I'm not on mute. do you also find us boring? Okay, tomorrow at 10 a.m. Hello? Can you hear me?
Yes, yes, we can all hear you, my lord. Thank you.
Thank you, my lord.
As
Okay,
it
so
pleases the
tomorrow
court.
at 10 a.m.
As the court pleases, my lord.
Thank
Thank
you,
you,
my
my
lord.
lord.
Okay, thank you. Court is adjourned.